To start, good afternoon. Most welcome to our speakers. Most welcome to you, Mr. Vulcan. Welcome also to our online audience for this annual conference on better lawmaking organized by the European Parliamentary Research Service. I would like to thank you all for being with us now. Why are we organizing this conference? Like our institutional partners, the Commission and the Council, the European Parliament strongly believes that in challenging times such as these, it is more important than ever to legislate as efficiently as possible to the benefit of the European citizens and stakeholders. To this end, the European Parliament constantly reflects on how to improve the way the European Union works and legislates. Moreover, we are fully aware how important it is for people and businesses that lawmaking happens in a transparent and participatory way. For this reason, the European Parliament is strongly committed to the EU's better lawmaking agenda. In July, just before the summer, Parliament, under the leadership of MEP Timo Vulcan as Parliament rapporteur, adopted its latest position on the European Union's better regulation policy. And we are very pleased to have you with us today, Mr. Vulcan, as a keynote speaker. So, following his remarks, there will be 3 consecutive sessions this afternoon. The first one will take a step back to reflect on how the better regulation agenda has evolved over time and what are the key challenges for the future. The second session will then zoom in on the setting of the legislative agenda. Here, the question is, how can anticipatory governance and better lawmaking help us to find new and beneficial avenues for EU action, and how to make such legislation future-proof? And finally, the third session will foster a debate on the Commission's new one-in, one-out approach, which it has begun to implement, with the intention to further reduce regulatory burden for citizens and businesses. And the roundtable will share views on the potential value and drawbacks of that new approach. In the context of implementing the interinstitutional agreement, Parliament has made substantial progress over time and created capacities to meet the needs of a Parliament that is also stepping up more, not only scrutinizing legislation, but also proposing its own views. The Parliamentary Research Services supports the institution and its parliamentary committees with a wide range of related products and services, from ex-ante analysis to ex-post evaluation to European added value work. The aim of such research and analysis is to try to help to generate European legislation of the highest quality in terms of simplicity, clarity, consistency, and effectiveness. And a single event, even if held annually, is not enough. The European Parliament, therefore, has another important objective in this conference. The Parliament wants to reach out to you, to our partners with shared interests on better lawmaking. We believe that by enhancing our cooperation with you through regular contacts and sharing of best practices, we will be able to do our part even better. We would therefore like to see today's conference as a further step in our efforts to establish an enlarged parliamentary community of best practice on better lawmaking with you, and to continue and deepen this exchange in future editions of the conference. In this spirit, EPRS stands ready to engage in dialogue and cooperation at all levels to evaluate progress and to find appropriate ways and means to best enhance the quality of the lawmaking process. It should be noted, and in the spirit of joining forces as co-legislators, the Czech presidency of the Council is organizing this week in Prague another conference on better regulation, crisis legislation, lessons learned or missed opportunities. And Part of this is actually very much pressing. We had discussions this morning at the conference of committee chairs, and I'm sure it's going to come back with State of the Union debate next week. How much, for example, the urgency legislation should involve the parliament or not, on which legal basis are chosen for these pieces of legislation. So we see it's very much at the core of the discussions now. We look forward to exchanging notes on our respective conferences this year and coordinate our efforts even further in the coming years. So once again, welcome to our conference today. I hope you will be able to enjoy many opportunities of fruitful exchanges, and that the conference as such will contribute to achieving our ultimate and common goal of better laws that can serve society well, no matter how the future evolves. And without further ado, I would like to give the floor to hand over to Timo Völken, who is the rapporteur on better lawmaking. He has been a member of parliament since 2016. He's from the group S&D, elected in Germany. In his political party, he's coordinator for the Committee on the Environment, Public Health and Food Safety, ENVI, and is a member of the Committee on Legal Affairs. He has areas of expertise in environmental issues, healthcare, legal affairs, and all things digital, from e-health to tackling geo-blocking. He was rapporteur of the Parliament's most recent initiative on better regulation and put the focus on advocating a more sustainable climate policy, progressive health policy, and future-oriented digital policy agenda. So we are very pleased to have you with us, Mr. Völken, today, and we are very happy to hand over to you for your initial remarks.
Yes, thank you very much, Etienne, and thank you very much for this very kind introduction. And I would like to thank at the beginning the EPRS for organizing this first of what I hope to be many annual conferences on better lawmaking. It's really necessary that we discuss the issues at stake. You, for example, mentioned rightly the fast track procedure. That's fast track procedure in the lawmaking process always comes with less involvement of public scrutiny. So there are advantages and clearly disadvantages. But better lawmaking still is a common goal for all European lawmakers. It is the core of our work, and we owe it indeed to our citizens who elected us to make sure that European legislation is fit for a purpose. European legislation is proportionate, clear, and comprehensive. And we can only achieve these objectives by increasing transparency, increasing accountability and cooperation between the institutions, and also between member states, citizens, and stakeholders. And that is why exchanges such as this event are so important and of so high value. And I'm glad that you asked for my brief keynote, and I'm very happy that I can be here today. You mentioned that I have been the rapporteur of the Parliament's initiative report on better lawmaking. And in this report, we emphasize the importance of transparency and proper procedure in order to increase trust in legal lawmaking processes as a whole. And I want to outline in a second 3 examples where I strongly believe we need to improve. But first, I think what we are realizing is that people turn their backs towards democracy when they feel it's not transparent, they are left out of the process, and their will is not implemented properly. And we need to avoid that, and we have possibilities to do so. 3 elements we focused on in our report. The first one is the role of the Regulatory Scrutiny Board. It is, from my end, from Parliament's end, painfully obvious that the RSB lacks transparency. We have a board that is composed of 7 members, none of them elected but appointed in an internal hiring process. And this means that the members are not accountable to citizens. They are not accountable to us as policymakers or even the member states. Additionally, 4 out of 7 members of the board are Commission employees, and decisions are taken by a majority vote. This means that the Commission could, in theory, overvote the other members whenever it wishes to do so. And given the serious shortcomings, I'm concerned to see that one of the objectives set out by the Commission in their better regulation communication is to strengthen the RSB. Let me underline this. Under no circumstances should we increase the powers of the RSB without also reforming the way it is run. As it stands, it is incredibly difficult, even for us, to understand why and when board meets with stakeholders, how it reviews impact assessments, why it reaches certain recommendations and opinions. And in last year alone, 1/3 of impact assessments received a negative first opinion by the RSB, leading to delays in pushing Commission's proposals. Yet it is basically impossible for us to understand in a timely manner why the board rejects certain proposals and not others. And this leads to frustration, and in cases such as the due diligence directive, to increase pressure on lawmakers to work more quickly once the proposal is actually published. The same delay is unfortunately now happening with the revision of the basic pharmaceutical legislation. And trust me, this revision needs to happen fast, as the current rules are 20 years old and outdated. So the RSB can only provide an effective check on the Commission's work if its independency and impartiality are indisputably established. And therefore, we are calling on the Commission to guarantee the independence of the board, to enable full transparency of the board's meetings with stakeholders through the Transparency Register, and to publish reviews, recommendations, and opinions immediately. Transparency creates trust. That's what I said in the beginning, and I need to repeat it. And the opposite, closed-door meetings and secret opinions, create suspicions. And I do understand all citizens who are suspicious about closed-door decisions. So we need to change it. The second thing I want to focus on today is the one in, one out principle, or in a more softer wording, approach. The Commission introduced this approach unilaterally without prior impact assessment or consultation of the European Parliament. I know some colleagues also believe that the one in, one out approach is good. And I'm deeply, but I'm personally deeply skeptical of this approach and the resources that will be required to set it through. And I know that many members are sharing these concerns. We are going to use resources that could be more productively used to draft, for example, better laws to avoid a negative impact assessment by the RSB. Moreover, the Commission itself, in its communication 2007, in one of its communications in the year 2017, entitled "Completing the Better Regulation Agenda: Better Solutions for Better Results," the Commission expressed reservations about the one in, one out approach and fixing ex-ante burden reduction targets, considering that it would create deregulation pressure and impair its political responsibility to deliver what needs to be done when it needs to be done. And I firmly believe that there is indeed a real risk that this approach leads to harmful deregulation because the Commission is forced to repeal regulation. And this is why we as the Parliament are calling for this approach to be based on a transparent and evidence-based methodology, giving proportionate consideration to all sustainability aspects. And Etienne, you rightly mentioned that I put a focus here and that my report did put a focus on sustainability aspects, because this is what more and more citizens are deeply concerned about, both in terms of benefit and costs. including the costs of non-compliance and inaction, and taking into account the administrative or economic impacts, while also considering their social, environmental, and public health impacts. Practically, this means that the one-in, one-out calculator has to be public, and that the co-legislators should need to give their explicit approval before the one-in, one-out approach is applied. And I would be interested to see if the Commission, and you mentioned the urgency procedures, you mentioned the historic challenges we are living through. You mentioned this, and I'm really curious if the Commission would have had the time to introduce laws which should be withdrawn because, for example, they proposed Repower EU legislation. I don't see this happen in practice. This will slow down us, and that's why I'm so concerned. But let's zoom out a little from these more technical considerations. As I mentioned in the beginning, better regulation is about better procedures, which enable citizens to trust in the European institutions. While it is important to look at the nitty-gritty of our procedures and make sure that they hold up to our standards, it is arguably even more important that we remain true to our democratic principles in very public questions. And in this regards, I would also underline that the impact assessment, together with stakeholder consultation, both of which are important tools to reach well-informed decisions and to promote accountability and efficiency, yes, but they need improvement. Still, there is a lack of communication in all official EU languages. Yesterday in the committee meeting, in the jury committee meeting, today in the ENVI committee meeting, members complained that they don't have access to the documents in their language, in their mother tongue, and they have the right to have access to the documents in their mother tongue. So this is not really a theoretical problem. It really stops lawmakers from participating like citizens are expecting them to participate. And this is a problem. Roadmaps, impact assessments tend, unfortunately, to be published more and more in English only. And this leads to the possibility of exclusion of some groups to be able to take part in the consultations, not only in the political process, but also when it comes to the consultation of citizens, of NGOs, of companies. And I think this really derives us from possibilities to take on board all views. So we are weakening our proposals by this, and this should not be accepted. In this context, it is absolutely critical for the trustworthiness of the European institutions that we keep our public political commitments, which includes the Commission staying true to the commitments as well. And here I would like to quote the Commission once again, or its website. I'm reading this. The Commission believes that the EU is characterized by its cultural and linguistic diversity, and that the languages spoken in the member states are an essential part of Europe's cultural heritage. The EU therefore supports multilingualism in its programs and in the work of its institutions. The use of languages and the respect for linguistic diversity have been of key importance ever since the European institutions were created. Quote ends. On a side note, and I'm aware this is a far stretch, so yeah, maybe, so this is the quote. I think this is the standard we should all work towards. And now on a side note, and maybe this is a bit far stretched, but it's also an issue of better regulation. And I believe it's worth mentioning it, especially as the elections of the European Parliament are fast approaching. I believe that the most important question in relation to accountability and transparency of the European institutions is the following: who chooses the person at the top? And right now the answer is, unfortunately, not the European citizens. Nothing does more damage to citizens' trust in the European institution than the member states taking such an important decision: who is at the top, who is the Commission president behind closed doors in a game of political poker. Even if we reform the RSB and make the one in, one out approach accountable and not harmful, as long as we do not solve this very fundamental issue, citizens will continue to mistrust the procedures of the European Union, and I believe for good reasons. Commission President von der Leyen is a product of this closed door way of making politics in Brussels, and we also need to underline in the headquarters of the member states' governments. How could citizens trust her to increase transparency and accountability of EU lawmaking if she herself embodies the lack of transparency and democratic choice that the EU is often accused of? Of course, I do welcome that the Commission is looking at ways of improving the way regulation is made in Brussels. It is so important that we all engage in it to improve on procedures such as the one in, one out approach and the RSB. But a truly accountable, transparent and trustworthy European project starts at the top. This is why I hope that the next election will finally see the implementation of the Spitzenkandidat process to guarantee that citizens wield the power in the EU, not backroom deals behind closed doors. And with this, as I said, a bit far stretching, but I still believe fundamental also for the way of how we consider better lawmaking, important approach. I believe that this is important. So, and with this, I would like to thank you for inviting me. Once again, I would like to thank all organizers of the EPRS for having put together this event. And I hope that this will be the start of a new tradition today. And yeah, thank you very much for your attention so far.
Thank you very much, Timo, for setting the scene so effectively, and also from your position as a politician to give us the wider picture of what is at stake, namely this connection with the citizens. Extremely important. We had a very positive Eurobarometer earlier this week, but it's fragile, and we know that public opinion can turn the other way very rapidly. So we have to deliver and to create confidence with the citizens. It's an everyday challenge. And I noted also that you highlighted the coherence of the EU system and how the leaders are elected. I mean, we understand that it's basically the Spitzenkandidaten system, that when you vote for a person, this is the one that is then ruling. And I'm sure that this is a question goes a bit beyond what we understand classically under better lawmaking, but this is certainly a question that will be on the desk of the parliament for the next months to come now, because in 2 years' time, the new parliament will have had already 2 sessions. So, so time is going to fly very quickly. Many thanks again. And I would like to hand over now the moderation to Elina Kartinen. Elina Kartinen is the head of unit in our own EPRS, responsible for this question, and she will moderate the session and introduce the next speaker. So many thanks again, and over to you, Elina.
Thank you very much, Etienne, and thank you also for Mr. Wölken. And those of you, we have about 131 participants, and those of you who could not join us from the beginning, we just heard from the European Parliament's rapporteur, Timo Wölken, on better regulation. And you, my colleagues have put in the chat a link to the Parliament's report that was voted in July, so for your further reading. So once again, welcome all the panelist, audience, and like Etienne set the scene, this is a session that will both take a step back. So we reflect a little bit how the better regulation agenda has evolved over time. And then we hopefully will also look at the key challenges for the future. And before presenting our distinguished panel today, I would like to give you a quick script on how this first panel will run. I will first give the floor to all our 4 panelists, and then for 7 to 8 minutes, and then we will have a question and answer session. And we will have more or less about 1 hour to our session. So and in the meantime, I encourage our audience to write as many questions as possible to the chat, because we would like to thank you already in advance to make this conference as interactive as possible. And now to our distinguished panel, we have Mr. Pascal Lardini, who is Deputy Secretary General and Chief Operating Officer at the European Commission. We have Mr. Rolf Höjer, who is a Senior Advisor and Coordinator of Better Regulation Agenda in the Swedish Government Offices. We have Mrs. Christiane Arndt-Basel, Head of the Measuring Regulatory Performance Unit in the OECD, and Mrs. Sasha Garben, Professor of EU Law at the College of Europe. And I will start this session very quickly and give directly the floor to Mr. Lardini, who certainly doesn't need much of a further introduction in this better lawmaking family. So thank you very much, Mr. Lardini, for joining us today. A warm welcome, and the floor is yours.
Thank you, and good afternoon to all participants. Thank you for having me this afternoon with you. And I would like to make a few introductory statements on what the Commission has been doing in the last years on better regulation, but also to respond to some of the statements made by the rapporteur, to which I would like also to extend my thanks for the very rich and very good report he has prepared a few months ago. So first of all, as you know, we are working within a very elaborate framework of better regulation. Last year, the Commission issued a communication explaining how it sees the evolution of better regulation. And we have followed this with action, because we have changed a number of features in the better regulation, and in particular, the very practical toolbox that we are using and the guidelines that we are giving to the services. For example, now to cover more in detail equality, fundamental rights, and human rights in the impact assessment. So we consider that we have a very mature, very all-encompassing approach to better regulation that we try to implement as much as we can. I would like to touch maybe on 3 points that the rapporteur has mentioned, and I take them in reverse order. On consultations, we have listened to the feedback we have received from stakeholders and from the Parliament to consolidate the way we organize consultations, to be more targeted and to be more precise in the questions we are posing. So we have changed our system now. We have a single approach to consultations called Call for Evidence. And we try to be more focused, as I said, clear, user-friendly. And what is very important, and that responds to one of the recommendations from the Parliament, this will be available in all languages. And it has started. It will be available in all languages, and we will improve also the way we are responding to the call for evidence by giving more feedback, generalized feedback in terms of the overall number of replies, the origin, the member states, the sectors who have responded, and then later on in the following proposals that the Commission is making, explaining which provisions or which particular approach followed results from consultation with the public. So I think we have fixed a number of things there, and very soon, and even possibly immediately, you will see the difference and the effect on that side. The second one is a complicated issue of the one in, one out, and we'll have a dedicated session later in the afternoon. But first, I really want to reassure the rapporteur, this has never been conceived as a deregulation agenda. This is meant to control the administrative costs occurred by the final users of EU legislation. And I think this is very much in sync with what we do, for example, with the SME testing, is to make sure that the final destinies, being SMEs, industry, consumers of EU legislation, do not have to embark in an overly complicated administrative procedures or adding new administrative hurdles and burdens. So the one in, one out, as we've defined it, and there was a communication from the Commission explaining how we see it, is certainly not one in legislation, one out legislation. No, it's about measuring administrative burden and see whether new legislation maintains the overall balance. So when we are introducing some legislation in the environment or health field, for example, create inevitably some administrative burden, we ask our services to look into the area to see what other administrative burden can be taken back, just to maintain the sort of the burden at a reasonable level. The issue also, the link with the Sustainable Development Goals, the sustainability dimension that the rapporteur has mentioned in his report, is very important to us, and it's absolutely central. Clearly now we have moved from a sort of equal footing between economic, social, and environment. There is a stronger focus on the sustainability development goals and the impact assessment, which receive really primary attention. And the third dimension mentioned by the rapporteur was the role of the RSB. And there, I think we should not have a false process, because the RSB is never meant to be a sort of a new agency outside the Commission. It was set up a number of years ago to help the Commission making better decisions, and it has evolved towards an independent body. You referred to the fact that it has 7 members. None of them are engaged in any operational activities. They work full-time for the Regulatory Scrutiny Board. And this functional independence has been recognized both by the OECD in their reports on the better regulation system in the Commission, and also by the Court of Auditors. So clearly, you know that for us inside the Commission, the RSB is seen as the sort of the guardian of better regulation, because it has the power to bar the route of the college for the proposals which have not met the necessary standards of quality of better regulation. And in terms of publication of the opinions, they are published immediately with the proposal coming from the college. And if there has been a negative opinion from the board during the process, it is published as well. So anybody can see how the proposal has evolved, how the points addressed by the negative opinion of the board have been responded in the final version of the impact assessment. On top of that, the RSB is publishing an annual report where you can also find quite interesting and important information. Maybe one word to finish, which is really a concern for all of us, which is legislating in time of crisis. Now, we have, unfortunately, a very long experience of legislating in time of crisis. With the economic crisis of 2008, with the migration crisis, and then the COVID crisis, and now the energy crisis. Now we have all to be agile and responsive to the needs of all constituency of Europe. We had to legislate very fast in the area of COVID, for example. The Parliament has followed, responding extremely fast to proposal from the Commission. We are very grateful for that. On the one hand, you can say, okay, we do not accompany this with the full better regulation impact assessment consultation process, but at the same time, we were also working, and that's particularly the case now for energy, for instance, on areas where the parameters of action are relatively well documented. One of the features we have also introduced with the new better regulation approach of the Commission is that in all cases, we will be publishing an analytical document, if not at the same time as the legislative proposal, at the latest within 3 months of the proposal. So in time for the co-legislator to see all the parameters of actions. But I recognize this is a difficult area on which we all have to work. I would leave it at that and wait for the debate after the other speakers have spoken. Thank you.
Thank you very much, Mr. Lardini, for these insightful remarks. And I move directly to Mr. Rolf Höjer, who is joining us from Prague, where our colleagues from Council are holding the event. And so thank you very much, Rolf, for doing 2 events at the same time and on the same topic. So very grateful that you can be with us today. And we look forward to working with you also in the future, because I know that you will be taking over the better lawmaking file in the incoming Swedish presidency. So Rolf, welcome, and the floor is yours.
Well, thank you very much. First of all, let me say that it's correct that I will be sharing the Working Party on Better Regulation in the Swedish presidency, so I will certainly be working with this. This being said, I absolutely talk in no capacity as an official spokesperson of the Council, so don't take anything I say in that manner. It's more personal, professional reflections that I can offer to you. Let me secondly say that I think it's really encouraging that the European Parliament is now showing this interest with this conference and other recent publications, and I really think that's a good work, and that will certainly continue very forcefully, I think, and hope. Now, I've been asked to offer some brief reflections on the state of play of better regulation, what has been achieved, what's not been achieved, and also possibly some few lessons about that could be learned from the time of crisis. A few reflections that are personal, but maybe shared by some other people, I think. First of all, it seems to me that we have now had a better regulation agenda for almost 20 years in the European Union level, and it's the case that I think you can say it is a fairly well-established agenda. There is widespread practice. It's often ranked highly by the OECD and is fairly comprehensive. So I think we should congratulate ourselves, congratulate each of the institutions having achieved this. On the broader level, this doesn't mean that it's perfect. Certainly some improvements can still be made. And I think this agenda encompasses things like impact assessment, ex-post assessment, consultations, and also now the one in, one out regulatory budgeting principle. And each of those can be very valuable instruments. The European Parliament Research Service recently published one report which I thought was useful, and perhaps Ann-Cecile, you can publish the reference in the chat to that report now. And one of the conclusions made by the author of that report was that the EU BR system now stands out as one of the most sophisticated in the world. At the same time, this system still suffers from a general proliferation of overall goals with too many North Stars, resulting in a lack of clear direction. And I think there is some truth to this statement, actually. We have tried in the better regulation system perhaps to cover a very wide area of different kind of goals and objectives to be addressed. And sometimes it's a little bit difficult to see clearly, transparently, how they are weighed against each other, etc. So I would tend to concur with the author of the report that slightly more focus might be useful. Secondly, a complaint that I think we've all heard frequently, and I've certainly heard it from other member state colleagues, etc., is that we don't always live up to our principles. Each of the institutions have clearly made a commitment to provide the impact assessments, and in many cases do so very well. But obviously, there are also cases where each of the institutions do not do so, perhaps with the frequency desired or originally intended. And there, I think many would share the sentiment that it would be useful to step up the ambition level to provide more impact assessments to accompany more proposals, basically. This being said, many of the impact assessments are of a high quality. Thirdly, a slightly less discussed point, I think, is that we do have a set of procedures that we call better regulation agenda, etc., that we go through in order to ensure that the end result in terms of rules and regulations being decided are good rules in some qualitative manner. But we have relatively little, I think, empirical knowledge about the correlation about how you use these procedures of better regulation and how they actually result in good rules. There are some empirical measures, or have existed some empirical measures of what you can consider to be good rules in some sense, such as the ease of doing business index, now discontinued, unfortunately. But it would be interesting to see some more systematic study of what is actually the correlation between better regulation procedures on the one hand and outcomes in terms of of high quality rule systems on the other hand. And I think that is something that could be possibly stepped up. Now, secondly then, lessons learned from the crisis, and I will limit myself to talking about the COVID crisis. As the previous speaker has mentioned, there's been several unfortunate crises. Well, one lesson I think is that to the extent that we hopefully have overcome this crisis, it's largely through mass vaccine programs. And these mass vaccine programs have, to a fairly large extent, been driven by extremely rapid, innovative product development work being done by a limited number of medical companies. They have certainly received financial help from public institutions, for which I'm sure we're all very grateful. But the innovative work has been done by this limited number of companies. And I think this indicates that innovation can certainly be one way out of a crisis. And I think it also indicates to us that regulatory frameworks that we adopt need to be sufficiently flexible, sufficiently permissive to allow innovation to a large extent in situations such as this. Secondly, it's a little bit in the nature of crisis that we're always surprised when they occur to us. We're always a little bit shocked. And this indicates to me that, one, we probably do need to develop our foresight capacities and try to be better at monitoring this. But even given the recent initiatives to further develop foresight, we have not been very well able to foresee crises such as the COVID crisis. Once it was there, we were rather taken by surprise in some sense. Retrospectively, we could identify the risk, but we couldn't really predict the risks as such. So there seems to be some limitations as to the ability of foresight and anticipatory regulation to some extent. And this it suggests to me that you need to be a little bit cautious about your ambitions about being able to regulate for the future, if I put it that way. And to some extent, you need perhaps to have a regulatory system that allows the actors, the individuals, the businesses, the flexibility to adapt to changing circumstances. Lastly, obviously, the speed with which a crisis occurs means that you often have to act very rapidly when making decisions about rules and regulations, and therefore you don't always have time to do impact assessments, just as indicated by previous speaker. Obviously, it's important to have things like sunset clauses, that you have expiration dates for legislation decided. Also that you have these kinds of ex-post reviews or analysis that have been mentioned earlier also. It may also be useful to have some kind of criteria. I know this is very difficult, but actually some criteria determining or indicated when do we think a crisis has occurred that is so serious that it's, should we say, permissible to step away from doing the ex-ante impact assessments, etc. I know this is a very challenging task, but nevertheless, I think it would be useful. Thank you.
Thank you very much, Rolf. And here we at European Research Services, we have very good working relationship with OECD, and the better lawmaking is not an exception as a policy area. And therefore, we're very pleased to have you, Christian, today with us. And we follow very carefully what our colleagues in Paris are writing. So I'm happy to give you the floor now. Go ahead.
Yeah, many thanks, Elina, and many thanks for the invitation. I think this is particularly great that this initiative comes from the Parliament. I think we would like to see that in more OECD countries as well, that Parliament really takes the better regulation agenda seriously. It's done in the budgetary field, why not also in the field of regulatory quality? So on the topic, I think I will echo quite some point of the previous speaker, Rolf. A lot of the notes I've taken, I think they're very much aligned. Let me start with the importance of all the actors in implementing the better regulation agenda in the European Union. We need to make sure that we have everyone working together. The European Commission, the Council, Parliament, and all member countries. All of them need to have good practices in better regulation, but they also need to work together. It's not a question of working only in isolation. As Rolf already mentioned, both in our better regulation practices across the European Union report, but also in our regulatory policy outlook, the European Commission it's shown that the European Commission has a quite sophisticated system, and it scores far higher than any of the member countries in all three areas. That's regulatory impact assessment, consultation practices, and ex post evaluation. And in particular, it's particularly striking for ex post evaluation. Now, that said, it doesn't mean that the system is perfect. The European Commission does not reach the top score either. And also, we do not measure everything that matters. So we could say everything that's in the indicator matters, but not everything that matters is in the indicator. We have never done an in-depth review of the European Union, of the institutions of the European Union, to see how they are working. So there are a lot of elements that might be really good that we are missing, and there are also elements that might need to be improved that we are not looking at. Now, we have not looked in our recent work, so we have the better regulation practices across the European Union report that looks mostly into what do the member states do in terms of practices separately, what does the Commission do in terms of practices separately, and how do they work together, in particular in questions related to negotiation state and also transposition state of EU directives. We have not looked into Council. It's more on an anecdotal evidence that it seems that so far the role in conducting, for example, impact assessments on amendments made in its committee seems to be limited according to information we have, but we have not done any in-depth assessment of the other institutions of the European Union. Now, negotiation stage. What we find is that a minority of EU member states consult with and consider the impact of EU law on domestic actors before it's adopted at the EU level. So that means that many member states actually complement the European Commission analysis with domestic impacts or consult with local stakeholders. And it was raised as a problem. We had a recent conference in June where a better regulation conference hosted in Brussels by the European Commission, where we had a lot of in-depth discussions on what can be improved in the system. And it was raised as a big problem that it's not clear for in the negotiation phase for member countries what the actual impacts are domestically. Now, let me raise some of the ideas that came up in this conference, which is partly under Chatham House rules, on how this can be improved. This does not mean that the OECD endorses any of those suggestions. We have not done any in-depth assessments of what the impacts would be, but I just think it would be useful to share this with a wider community, because we had a brainstorming, there were quite some concrete good ideas coming out of it, and it would be nice to take this forward, the discussion on whether this could work or not. So, for example, it was suggested to create an interinstitutional body with experts from all three EU institutions to follow the development of the better regulation processes and to find solutions that would be appropriate for all. It was also suggested to create a dedicated unit, which is external to the co-legislators, that would oversee the production of analysis of significant amendments. It was also said that various working parties involved in the Council of the European Union already have established procedures and guidance to develop and use data analysis to form a negotiation of proposed EU law. However, that's not always necessarily adhered to. So there was also the idea to use these existing guidelines, potentially also improve them, but also make sure that they're actually being used in the working parties. Issue of resources was raised, that in general there are not enough resources in all institutions for the better regulation agenda. What was also raised is that the EU member states should support their national authorities to use both to use the European Commission's impact assessment, but also they should also prepare information on the domestic impacts. Now, the issue that was raised is that the negotiators, which are representing the member states in the Council, are not necessarily experts in the technical area. So it was discussed it could, for instance, be useful to provide them with a short note that summarizes the content of the European impact assessment and of any complementary analysis that was undertaken domestically. It was also raised that member states could involve more the relevant ministries. Sometimes this process is driven by the Ministry of Foreign Affairs, not always the relevant experts in the ministries are involved. Sometimes they only come in at the transposition stage. So we said it would be much more useful if they're involved early on when there's actually a discussion of the proposals. Now, interestingly, obviously there were also challenges raised, including, for instance, a challenge of timing, and that comes back to the topic of crisis. Sometimes there is the question, how quick do you have to react to get the best evidence? How do you find the right balance on that? Now, if we go to the transposition stage, we have a contrast here. because there almost all EU member states consult affected parties or assess domestic impacts when transposing EU directives. However, what's missing at that stage in many member countries is that there is no clear, transparent assessment of what's called gold plating sometimes. If there can be good reasons that member states go beyond what the Commission proposes, but that's not always transparently put out. So there was a discussion of potentially creating so-called transposition workshops where all EU member states could discuss how to best implement each directive so as to limit divergencies, ensure unless they are necessary, and ensure the homogeneity of the single market. Now let me come to the theme of in time of crisis. I could just echo that. I think the top points I want to make on this is, number one, is every emergency really one? So that's the whole question of transparency and making sure this is not used just to bypass the better regulation requirements. But also the second point I want to raise there, if there is a real crisis, the problem is you have no time to get it right, but you have no time to get it wrong either. So that's the issue. So can you really allow yourself not to use any evidence, not to consult with anyone to see if that actually plays out in practice? So probably the idea again here is to use some kind of middle ground, to think about some limited analysis that can be done and stakeholder consultation throughout the process. And we have seen that with COVID, for instance, I mean, in a number of countries. Here, again, to be prepared up front. There are some tools and concepts that can help to manage crisis and not just go there without any evidence. Issue of risk-based regulation. So far, we only see 7 OECD member countries and the European Union which report having an overall risk and regulation strategy, including requirements for systematically considering risks when developing rules, which does not mean all of them have implemented it, but at least they report it. So again, here, very important, if these tools are there, it is easier to manage a crisis such as the COVID crisis if the capacities are actually there, and to make sure that the responses are risk-based. For instance, one example everyone knows is that, for instance, there was too much emphasis on hand disinfection compared to mask wearing at times when it was actually evident what would work better already from a scientific point of view. Capacities for strategic foresight, using data and new technologies, again, this needs to be planned in advance. I can maybe just point here also to our recommendation on agile regulatory governance. We have a survey on agile approaches to the regulatory governance on innovation. All of that you can find in the chat. There are a lot of new ways and approaches which work both in a crisis situation, but also outside a crisis situation to manage basically the regulatory procedures to move towards a more agile process on regulatory governance. We have done a lot of work on that. Currently, we're working also on regulatory experiments. We do work on new technologies in RIA ex-post evaluation consultation, data-driven approaches to facilitate effective risk-based regulation and enforcement. Again, here also to say is that the idea is not to use more data to build a state of surveillance, so you control more. The idea again is here that you use data in a way that you actually reduce the control so that you can target it better, that you have a better idea where the actual risks are lying. Let me just conclude with one point, because I saw in the chat there was a question on laws initiated by Parliament. Just to give a little bit of information on what we know on that on our member states, we know that the number of laws initiated by Parliament are actually more significant than a lot of people think in EU member states. However, very often the requirements in terms of better regulation, be it regulatory impact assessment or consultation, are either non-existent or they are far more reduced. We have not done any work on what would be appropriate in Parliament, but we do know from some anecdotal Chatham House rule evidence that in some cases this can also be used to bypass the better regulation tools. So just to have some reflections then as well on what procedures need to be in place for laws initiated by Parliament, where we don't have any normative approach, but obviously an important point to then also put up for discussion.
Thank you, Christian, for these great points. And I will put then the question also from Mr. Paolo Ponzano to everybody afterwards. But unfortunately, we don't have Mr. Völken anymore with us. But anyway, I will let you others comment on the Parliament's role here. But before that, I would like to give the floor to Sasha. And thank you for joining us today. And when we met before the conference, you warned me that you are going to be very critical in your intervention. So we are now here ready with our pens and papers, and I give you the floor. Go ahead, Sasha.
Thank you very much, Elina, and that is indeed correct. I fear that my approach to the better regulation agenda is a far more critical one than the previous speakers, including the already quite critical opening statement by the keynote speaker, Mr. Völken. My critique is not even just limited to pointed aspects of the design or operation of the agenda that then perhaps could still be improved, but it really is very existential. It's very fundamental. And indeed, it might lead to the logical conclusion, if you were to follow my argument to the extreme, that we would be better off abolishing the EU better regulation agenda altogether. And I only say this half to be provocative, half this is really where the argument leads me. Now, a lot of the work, the research that went into that assessment was done in 2018, so pertains to the previous incarnation of the better regulation agenda, but the agenda has, of course, mutated over time consistently, and my critique stands as much, if not more so, in relation to the current incarnation and the reinvention by the Commission, including the one in, one out approach. Now, that work was published in a book I edited on the EU Better Regulation Agenda, which I will now shamelessly promote in the chat. And what my contribution to that book was to provide, apart from editing it, was to provide an impact assessment, a little bit tongue-in-cheek, of the EU Better Regulation Agenda. So to basically hold the agenda up to its own standards by way of an analytical device, because obviously I couldn't conduct a full impact assessment. But what that basically, I think, demonstrated was the very poor evidence base on which huge parts of the Better Regulation Agenda are based, the implicit problem definitions that are unproven, unprovable to some extent, but unproven as currently stands, as regards the idea of an over-regulating EU with disproportionate rules or unscientific decision-making, all the things that implicitly the Better Regulation Agenda is then apparently saying that if it wasn't for the Better Regulation Agenda, the EU would be doing. The assessment also revealed that, to the extent that there are certain correct identifications of problems, for instance, with a perception among parts of the EU citizenry of EU overregulation, that the agenda is actually not very well equipped to address that, rather counterproductive. Precisely as a PR exercise, because it seems to concede to the citizens that indeed the EU has this enormous problem and that we need all these institutions and all this money and all this apparatus and bureaucracy surrounding the better regulation agenda to curb this inherent zeal that the Commission and the EU would have to create all these unnecessary rules. And then what the assessment, of course, also used was to say, apart from that, there is the lack of a really coherent evidence of a problem and lack of evidence that the better regulation would be solving those. There is, of course, a very real direct cost of the better regulation agenda in money terms, which the European Commission itself in the stock-taking report, I think very usefully estimated at up to, what was it, 34 million euros a year. So we can, I think, then safely say that the Commission itself indeed acknowledges that over the 20 years that we've had the better regulation agenda, and in all the years to come, the tap is running in the millions of euros. So it is a little bit problematic, I think, to have those costs on the one hand and the very limited evidence of any added value of this agenda on the other hand. Now, for all the details, I mean, I'm happy, of course, in the Q&A also to go into that further, but I would like to just refer to my written work for that. What I want to do now is just make three central points beyond that. And so the first is that I think we really should reflect, especially the European Parliament, but all of us ideally, on what model of the legitimate exercise of authority it is that we are adopting here and what the better regulation agenda means in respect to that. I think it is fair to say that the better regulation agenda trumps technocratic ideal of decision-making and of law-making rather than one of representative democracy. It presents rulemaking and decision-making not only as something, as like a necessary evil that needs to be limited to the absolute bare necessities, but more fundamentally as not simply the expression of the prerogative of the people and their power to decide normatively on the rules that govern their lives, but rather as something that is either best left to the experts or then very much conditioned by the experts in pursuit or on the basis of an assumption that there is something of a right solution to certain questions, that there are questions that are apolitical or that should be apolitical. For certain EU institutions, that might be a more natural position to take. I think for the European Parliament, it is antithetical to its very raison d'etre. And so I understand why some of the European Parliament's actors are more critical of better regulation, but I actually, frankly, don't understand why the European Parliament is not far more critical at a more existential level, because I think the better regulation agenda, what it stands for at a more sort of philosophical level, but with very practical effects, is, I think, opposite of its actual, of the Parliament's being and essence. The second point, and I'll be short, I know I only have like 2 minutes left. The second point is that something I already alluded to is that it is that the better regulation agenda, I think, is a bit of a failed PR exercise. So for this, I refer to the work done by the scholar Daniel Kellerman, who went into that in more detail. The idea that there is indeed a perception, especially in a former member state, but in some other current member states of the EU, that there is an over-regulatory EU monster adopting unnecessary rules about cucumbers and whatnot, that is why we need something like a better regulation agenda. The problem is, as I alluded to before, is when you have the agenda as it is formulated now, is that you are basically admitting, you are conceding that indeed there is that risk and that we need all this effort, all these endeavors to curb that, to prevent that. Whereas such a negative narrative, I don't think is ever going to convince anyone. Instead, what I think, if you wanted to have, portray the EU in a more positive light, which I am, for instance, in favor of, then I think you have an enormous potential to celebrate the great achievements in terms of environmental standards, social standards, consumer protection standards, all the public interest rules that indeed might inconvenience or burden business, the ease of doing business, but for very, very good reasons. And that's also, I think, if you read a Eurobarometer, what citizens really care about. So rather than, in a way, shaming all of those rules, we should be celebrating them. And that brings me to my final point, is that not only the rules, but the process, the legislative process, should be celebrated and not implicitly or explicitly shamed. We have in the EU the most impressive accomplishment of transnational constitutional democracy with the community method, with the legislation that we can adopt, the checks and balances, judicial review by the Court of Justice, an elaborate system of transnational democracy. We should be proud of that. We should be celebrating that. And I think that the better regulation agenda does not do that very well. In times of crisis, really final point, it is often that legislative process that is a little bit put under pressure. But I think that it is precisely in times of crisis that we need people that are subjected to that crisis on board in validating the decisions that govern that crisis, to not apply better regulation requirements to governing a crisis, I think is very legitimate. What I don't think is legitimate is to not follow legislative procedures altogether because it would concern a crisis, something that the EU has been prone to do sometimes. You know, in the end, better regulation, the best regulation is democratic legislation. And I think that's really what I think we should keep in mind. Thank you.
Thank you very much, Shate, for this thought-provoking input. And I thought that while I encourage the audience to put more questions in the chat, I thought that I would anyway give still our panelists a short round of interventions. You could react to the interventions of your fellow panelists, and while we wait for the further questions. And I have few already here with me, but I give you a round of round table now once more. So, Mr. Leardini, please, the floor is yours.
Thank you. I don't know where to start actually, because I was a bit shocked by the last intervention, frankly. And it seems to me that there's so much detached from my daily experience of legislating at EU level and the interaction between the institutions. And better regulation is not there to curb the monster or any monster that would be down there, not at all. I mean, the regulatory scrutiny board is giving opinions that the Commission, the College, in its political wisdom, can ignore if it so wishes, and that the Parliament can change completely a proposal from the Commission afterwards. So I really don't understand this criticism about the negative agenda. On the contrary, indeed, we are extremely proud by the successes of the European Union on the social agenda, on the environmental agenda, on a number of telecom legislation, on the GDPR, for example. So there are many, many successes, and I think the better regulation has helped and not hindered the achievement of these successes. So, but this is a more philosophical debate, and as a former student of the College of Europe, I would be pleased to have this debate and maybe another time. Now, two remarks maybe I would like to make on what our colleague from the OECD said very well. One is that we are focusing a lot about EU institutions, and in particular, because of the better regulation agenda started from the Commission, on the Commission. So we are all here completely convinced that we should cover all institutions. That's what the interinstitutional agreement of 2016 says, actually. And we are very glad to see that the Parliament has taken measures to now embark on this journey. By contrast, the Council has not done much, if anything, better regulation. And I think it's very important that they equally do assess the main changes they introduced to our. But then I very much agree that the cycle is not over. We have to think about implementation and the issue of gold plating added at national level. Now, the reference was made to implementation workshop with the member states. This is a good practice that we are developing in a number of sectors. So our DGs call on the representative of the member states after the adoption of new legislation and before the transposition date to look at the ways these can be done. What level, at national level, regional level, what sort of competence instruments can be activated. So that's very important point. The second point is about, Rolf said about the future-proof legislation. This is a very big challenge. We have introduced, as you know, the digital by default principle. We try to anticipate developments on the technological side, which will allow further developments. And I mean, clearly, this now goes much beyond the IT or digital area. Talking about digital digital-proof legislation in all sectors, including in agriculture, including in whatever you have. We need to have this dimension factored in, which is why also we are trying to develop new approaches like sandboxes, so possibilities for having objectives set in legislation, rather precise means to achieve these objectives. We have that in new legislation, and then we constantly review and monitor to see in what direction either the private sector goes or regulators go before we sort of fix it in stone if necessary, solved by itself or by other means, so much the better. But clearly this is something we try to experiment, which is new and which is also a common challenge. Thank you.
Thank you so much. Rolf, do you want to come in?
Sure, thank you. Well, I think that Sasha was probably raising the most fundamental issues to some extent, so I will try to say a few words about what I think about some of those. Now, I don't think I'm quite as negative in my assessment as you are. I do think, like I stated, we still don't have a very clear empirical picture about the correlation between, on the one hand, better regulation procedures and the outcomes in terms of high quality legislation, and I would welcome studies. That does not mean that I presume that the conclusion of such a study would be negative or that we would actually see negative results. I think we would probably see positive results, I would say that, and I don't think we spend too much money on better regulation either. Now, you touched on some important issues, I think. I don't personally think the issue is about sort of technocracy trying to pull in the reins of democratic sovereignty. Some of the scholars I've been paying attention to, like Radelli and Dudley, etc., what they suggest is that just like ordinary people may experience biases and difficulty in their decision making, so also regulators may experience biases and difficulties in their decision making. And in order to improve decision making, you need to set up as good a choice architecture as possible, or provide the best incentives possible for making good regulatory decisions. And I do think that the better regulation agenda is an attempt to set up some such choice architecture. Franz Timmermans, when he was in charge of these matters, made a statement during the conference in connection with the stock-taking exercise that they made at that time. And he said something to the effect that when you have a proposal regarding a new regulation, analyzing the positive aspects of that regulation, it takes care of itself, because you identify a problem and you identify in what terms the proposed solution is actually providing a solution to that problem. But then there is a number of other aspects of that proposal which may not be adequately considered. And I think that the most important function possibly of the better regulation is to draw attention to those other aspects. What kind of implications might a suggestion have in other policy areas? What kind of costs might it impose? How might it affect proportionality? And there I see possibly quite huge benefits, and actually very necessary benefits, of having a better regulation agenda. That being said, is the one we currently have the best one? I don't know. That's an empirical question, but I do see it now slightly more positive.
Thank you, Rolf. Christiane.
Yeah, I think there are a lot of really interesting points being raised. Yeah, for me, the better regulation agenda is not a technocratic agenda. It's a question then of how it's being implemented. Maybe to be a bit provocative, because it seemed to be that you were saying this is kind of opposite of each other. So how do you want decision making to function without any evidence and without any consultation? So that would be my question. Do you not want anyone to think about the impacts and just argue for whatever without having any thought about what would actually work in practice or not, to the point that then later on maybe whatever is implemented is not working? Because that's the other thing. In some way, the better regulation agenda is supposed to be there. If that's now working or not is another question. But also to see if what's promised will actually work in practice, and if there's not a better idea on how to do it. It's there to inform those who are either democratically elected. It's not to make the decision for them. So that's a bit the question. I would be interested in your view on it. Do you want to work without any evidence and just anyone can make statements and then let's see what happens? But I think you have a valid point in the sense is that we have to think about how we can make it more democratic or bring it closer to the people as well, because obviously there are a lot of challenges. I mean, thinking about consultation processes, for instance, who participates in that? Who understands the material? Who understands the evidence? How can we make the evidence in a way that it's understandable? How can we also make sure there's a real discussion around it? And that's a big issue in many cases is there a real discussion on the impact analysis, for instance, and who can understand it, and how can we reach the relevant actors as well and gather their views? I mean, I don't know what you're doing, but on Sundays, I'm usually not checking where I can participate in a consultation somewhere online. So it's a question of how we can do that. And there are a lot of models. There are also ideas I mean, you're all familiar probably with citizen panels, etc., for instance, which can have great results in also making it clear to citizens how hard it is sometimes to reach a decision, because you were talking about the importance of also celebrating what Europe does, but also maybe educating citizens about how hard it is. Everyone can come with, I want this, and the moment you try to find a solution together, it's not necessarily so easy. I think you have a big point on the communication and the positive side, because obviously very often there is this EU bashing, or generally there's bashing of the state on rules and regulations, that probably we need to talk not only about regulatory failures, but also about where regulation worked, but also where sometimes better regulation played a role in it. So, and that's hard to gather, because we were talking about the evidence. I know we don't have time for it. I'm happy to privately discuss with anyone the methodological issues on correlation or on causality and how you can do that. So happy to have a side discussion on that. Probably don't have the time for it. But just to say on the case study side, if you look into what countries know, the issue we face when we ask countries for examples where the better regulation agenda actually helped improve a proposal is sometimes they don't want to share it because they don't want to show that a ministry actually had put forward something which was really a bad idea, and then through the procedures it was actually improved. So sometimes we also have a hard time getting that evidence from countries because no one wants to say actually what we had suggested was bad. And in the same way, ex post evaluation, also not everyone wants to say, okay, we really saw these things are not working, so it needed to be improved. So that's one element of it. But I think we should think about how can we bring this closer to the citizens? How can this use to enhance democracy rather than doing the opposite? And how can we communicate also how that can work, and also invite people to participate and learn from it?
Thank you, Christiane. So Sasha, naturally to you now.
Thank you so much, and thanks to everyone for taking my provocations in such a sportsman and womanship manner. On the consultation issue, so this is something that I think I saw a question in the chat as well by Duncan Johnston. On this element of the better regulation agenda. So how can it ever be bad if we are just trying to, so isn't this actually very democratic? Precisely, right? Now, apart from what was, I think, very legitimately said already by Christiane, some of the inherent failures that scholars have reported as regards to the consultation mechanism, with the usual suspects sort of rigging the system, not really these public consultations at EU level, not really reaching citizens at large, and so on. I would sort of invite a bit more of a fundamental reflection there of what kind of model of democracy we are talking about when we talk about consultations, even if they were sort of a bit more successful than they have been up to date. And that is, again, not one very sort of compatible with the model of representative democracy, where the whole point is that what citizens do is they elect people, and those elected people will then make decisions in parliament. But rather, it is more about this throughput, legitimacy, deliberative democracy dimension, of where we want to then ask people that are concerned by the rules what they think about the rules in a kind of more ad hoc fashion. Of course, I think it is, there's nothing wrong in, say, with consultation. I think it will be very difficult to get it right. I think panels are great, but also, again, I'm not sure if they are the holy grail. But in a more general sense, you know, that's not my big beef with the better regulation agenda. I mean, I don't think that public consultations resolve every problem we have, but those are also not the issues that are, I think, potentially detrimental about the better regulation agenda. But I also don't think that the consultation, public consultation dimension is the main objective of the better regulation agenda. I think the main objective is driven by this cost-benefit analysis, the idea that we need to control the quantity and quality of EU regulation, because if there wasn't such an exercise, there would be enormous problems with that quantity and quality of EU regulation. And that I just don't see borne out yet in evidence, as I have already outlined. Now, I don't say yes, we should then have absolutely no evidence, but what my point would be is that scientific evidence is an input alongside other inputs that the democratic decision maker can take into account. But ultimately, as precisely I think the COVID crisis also showed, is that there are not only inherent limits to how easily you can identify what scientifically is the right option, but in more general sense, all those decisions have an impact on society, on the lives of peoples, beyond the strict confines of what you can scientifically measure and identify. And it is ultimately a normative decision on behalf of the people, how they want to take into account the variety of elements, which include certain elements of scientific input from one discipline, then from another discipline, and then they will have to make very difficult balancing exercises. And that is what real democratic decision making is. So that was specifically, sorry, to the point of Christiane. Yes, obviously there is a place for science and evidence, but it is one of the factors that the democratically elected decision maker can take into account and disregard if need be.
Thank you very much. And 1 hour is very short, but I thought that we have now questions from the panelists. So I would like to, from the audience, so I would like to do a very quick round. We have a question from Katarzyna Walczak from DG Agri to all panelists. And I start with these questions: what the EU institutions should do in practice to help OECD to push better regulation agenda forward and amplify the OECD efforts to regulate better for better life. And then she had also another question. I put that at the same time, so you can choose either to answer to both or choose the favorite one. Do you imagine one single better regulation common at EU level? And there she makes the reference to the co-legislators, but also to the committees and the Court of Auditors, if I understand right, and in the soon or medium future, and 5 to 10 years. So I'll give you the floor. I start with Mr. Lardini again.
Yeah, very shortly. On this last question, I think if I judge by the pace we have implemented the interinstitutional agreement on better regulation, I will not see anything of this before I retire. Because we will probably quarrel for ages about who will chair the committee, where it will be located, who is acting as the secretariat, who is going to pay for the coffee, and who is going to make the report. So, frankly, this might be a theoretical model where we could, in theory, have an interinstitutional body working on legislation. But then, and I think that's one also reflected in another question, is that all the institutions have to play completely the game. And if that body would consider that an amendment by the parliament adopted by democratic representativeness is not good for better regulation purposes, or it will have a detrimental effect, then that voice will have to be heard as well. So, I mean, it's again, I think we should not just have a theoretical discussion about it, things about what actually it means in practice. Now, I think the better we can do for the better regulation agenda is to talk to people outside this bubble, that it matters. that the impact of what we are doing in legislation matters, being environment, social, or economical impact, and it all now it's subset, which are all very much detailed. I mean, it all matters, and we have tools to show, to give evidence that or data or relevant information about what it could mean in practice. And the more we can sort of disperse this message outside the pure better regulation community, the better.
Thank you very much. Rolf, last remarks on possibly these two questions or something else that you want to add now in the end?
On the two questions, I think it's overly optimistic to see that kind of progress that quickly, unfortunately. As to what can you do in practice to push the BR agenda forward, I have the impression that in the BR community, those actually active in the field, there is a fair amount of agreement on some underlying principles. I'm not sure to what extent those principles are actually applied in many other council configurations, etc., when you negotiate specific proposals, etc. So there should we say more systematic adoption and consideration of these aspects in the practical work in specific questions in the EU, I think would really help.
Thank you. And Christiane, there was a hand reached towards the OECD, so.
No, I think we had a really good discussion already today. How we can move forward. I think that's part of it. Is I think to think concretely about it and also how that would work out in practice, and to have those discussions and think about how things can be improved. That's very important. And I think we stand behind the idea that you need evidence and that you also need to talk to those affected and make sure that again, also that's the same in the process of making laws and regulations, to make sure they're based on evidence, to make sure that there's a real consideration of different impacts, to ensure also we look into some more long run goals, and to make sure that that it actually can work in practice. I think that's behind it. And to continuously improve on that, I think is very important, but also making sure it's implemented. And it definitely helps us as the OECD to learn from countries and from the European Union and the institutions as well on what works, what doesn't work, so that we can all improve on the tools that we have. I think that's very important, but also to provide, for us, it's very important that we get also provided with examples on where things are working and where concretely actually the tools have helped to improve, because that for the communication is very important.
Thank you. And Sasha, last academic remarks.
Thank you very much. Yeah, no, I'll be very short. So on the question about the single better regulation procedure, I would just emphasize once again that I think it would be wise for the European Parliament, precisely because, as I said, inherently, I think it might be the institution that sees most of its sort of raison d'etre challenged by the very underlying philosophy of the better regulation agenda, needs to be careful to not adopt the same approach as potentially some of the other institutions. But of course, that's for its own prerogative to decide on. And secondly, I just wanted to point out that even if, of course, I've been an outlier in all this, what I did sense was that maybe there wasn't as big of a disagreement on the point that it would be good to have a bit more evidence on the actual merits of better regulation. We may have different expectations as to what that evidence will eventually point at, but I think that we can agree that that would actually be a very useful thing to have.
Thank you very much. Now I will unfortunately, I have to wrap the discussion, and our director, Wolfgang Hille, will share the key takeaways in the end of the conference after all three panels. So therefore, my side, a warm thank you once again to all panelists, also to the audience, and please don't disappear. We continue with the panel 2, and hand over to you, Lauro.
Thank you very much, Elina. Good afternoon, dear participants, and thanks to be here. We are now starting session 2. In this session, we will focus on the European added value, anticipatory policy making, and new tool for better planning and results. I'm Lauro Panella, head of the European added value unit here in DG EPRS, and I will be the moderator of this session. In the next hour, we will zoom in to the front end of the legislative cycle when new priorities are set, trying to reply mostly to two questions. The first one is, considering the complexity of the challenges we face and the possible shocks, how can our legislation be better prepared and resilient? And the second question is, what tools could be used to help ensure that legislation is flexible and responsive to unexpected future and shocks? We have a distinguished panel with us today to help to answer these questions. We will first hear from Elisabeth Goldberg, who was Director of Smart Regulation in the European Commission until 2017, and now is a Senior Fellow at the Harvard Kennedy Schools. We will then hear from Karl-Heinz Lambert, who is the chair of the Better Regulation and Active Subsidiary Steering Group at the European Committees of the Regions. Thomas Larue will then share with us his perspective from the head of the Evaluation and Research Secretariat in the Swedish Parliament. And last of all, two colleagues, Mina Fernandez and Alexandra Elflich, will present our ongoing work here in the European Parliament Research Services from European added value to stress testing of EU policies. As with the previous panel, we will then open the floor for questions from you participants. So, dear panelists, it is my pleasure to welcome you to this EPRS event. Elisabeth, we will kick off with you.
Yes,
Please,
thank you, Laura.
the floor is yours. So, in your opinion, what is your perspective on anticipatory policy making and tools, and in particular the link between the analytical tools such as European added value analysis and foresight? So please, the floor is yours. Thank you.
Thank you very much, Laura. Thank you for inviting me to participate in this panel. I would like to congratulate the EPRS on their 10th anniversary. Certainly in the last 10 years, you've done a lot of very worthwhile, excellent work, and I hope it will continue. As many of the speakers today have mentioned, we have gone through many crises in the last 10 years, the Euro crisis, migration crisis, the pandemic, now an energy crisis. And certainly our policymaking landscape has dramatically changed. We have rapid technological change, disruption, there's volatility, there's uncertainty, and all of this, I think The Economist summed up a couple of weeks ago in calling it the new abnormal. We live in the new abnormal. So the question is, how is better regulation going to cope with this new abnormal? And what kinds of tools might we develop to deal with this new abnormal? When you asked me to speak, I asked myself a couple of very basic questions about this. I asked myself the question, well, the tools that we have for foresight and EU value added, are they working? Do we need new tools, or do we just need to use the tools that we have better? My second question was, are these really the tools that will help us deal with this new abnormal? And third, something that previous speakers have mentioned now, can you really draw a link between the use of better regulation tools, be it foresight or EU value added, and results? So my answers to my own questions are the following. I think we have the tools. I don't think we necessarily need new tools, but I think we have to deploy the tools we have better. My second question that I asked was, are these the tools that future-proof legislation? I think not. I think that comes in the design of legislation. And the third point is, I think it's very difficult to link policy results with better regulation exercises. But let me explain my answers in a bit more detail. We have tools. If I look at the last few years since I've been retired, and here again, I want to underline that I'm speaking on a personal basis, not as a representative of the Commission. If we look at the tool, if we look at what's happened in the last few years, the Underlying Commission has put tremendous priority on foresight. So I look, there's networks, there's reports, there's interinstitutional initiatives. And I think all of this is proving to be very educational for one thing. The question is it feeding into the policy agenda? There's resilience dashboards. There is a new tool in the Better Regulation Toolkit. And when I looked to try and determine or see if there was evidence of results, I could find a couple of things. The RSB, the Regulatory Scrutiny Board, for example, cites in its 2020 report some anecdotal evidence of impact assessments that have taken foresight into consideration. I've seen recently that the resilience dashboard that was developed out of this foresight exercise is being used in the European semester. So I think you see that foresight tools are being used. I think it's just a little bit too early to come to firm conclusions about how well they're being used. EU value added is another kettle of fish, if you want. EU value added, or the measurement of EU value added, has been a challenge ever since the EU was created. If something doesn't have EU value added, we wouldn't act. That's just that simple. EU value added has been part of the toolbox, part of better regulation, and certainly in my last years in the Commission, there was a major initiative on subsidiarity, and a subsidiarity grid was set up to help in the impact assessment, in the evaluation process, to make sure that subsidiarity, or the opposite, the reverse flip of the coin, EU value added, was adequately taken into account. And I think here, if you look at the RSB reports, you will see that EU value added is one of the elements that's best assessed in impact assessments and evaluations. It's not perfect. Certainly, whenever you go to assess benefits, there are challenges. When you do counterfactuals, there are challenges. We have issues with data, getting timely, accessible data, getting data that's standardized across member states so that it's usable. And of course, there's a challenge in using more modern data analytics techniques. Recently, the Court of Auditors pointed out that the Commission does have a lot of data in the agricultural area, but wasn't using the most modern techniques to analyze it. So anyway, my conclusion here is that we have the tools, we just need to use them better. Second question, are these the tools that can help us deal with crises, can help us deal with this new abnormal? Well, here I think it's more a question of legislative design. And I would say that we go back to the old discussion between directives and regulations. I think if you set the objectives, it's very important that you leave the means, that you do not go into too much detail on the means, but leave that for the member states to decide. And also a very important element, which was just mentioned in the last few minutes, is monitoring and assessment. I think we have to have means to monitor and assess in a timely basis, so that it feeds into an adaptive, a regulatory learning process, so that we can have the means to adapt our legislation in light of rapid change. Just a word of caution here. Certainly in my experience in the Commission, we had foresight. But I think there's a tendency for foresight reports and analysis to be sort of placed at arm's length from the decision-making process. That's a pity. But why is that? I think it's because you need to make foresight reports and foresight exercises operational. Policymakers have to be able to see how to use the results of those exercises. And I think that's very important. Also, a word of caution on impact assessment. We have so many tools and we have so many demands on those making impact assessments that we have to be very careful that we don't overload the boat. Impact assessment is there to help decision makers make decisions. We don't want to make them too complex. So my third point here is simply, I'm a firm believer in better regulation. I think we need better regulation to make better laws, better policies, but it is very difficult to make a direct link between our better regulation exercises and results. I tried myself when I was at Harvard. It's not an easy process. I encourage the OECD to look at this, but between the time that we conceive of an idea and when the policies are actually implemented and showing results, is usually 10 to 15 years. So it's pretty hard to conclusively draw a link between start and finish. Well, with that, I will conclude just by saying, if I were to offer a few suggestions to both to my previous employer, the Commission, and the Parliament, I called a series of C's. First is continuity. I think it's important that we build on the current system. It may have imperfections, but it works and it's a solid foundation. My second suggestion would be common purpose. I think you see where the institutions agree and have common understanding on the use of better regulation instruments, you see results. And so I think common purpose is very important. Commitment. Better regulation is fragile. It's like a diet. It's discipline. You have to have someone there to say, you do it, and make sure that it's done. And I think in that sense, you need high-level political commitment and you need high-level administrative commitment to make sure it's done. And the last point I make is just common sense. Sometimes common sense is the most underutilized tool in the whole toolbox. We really need a good dose of common sense. And I will conclude my remarks by quoting Keynes on this. And he is, perhaps it wasn't him, someone before him, but he said that it's better to be roughly right than precisely wrong. So I think we have to bear that in mind in all our better regulation exercise. Thank you.
Thank you very much, Elizabeth. Very, very interesting. And I would like now to give the floor to Carl, following what you said at the end. So continuity, common purpose, commitment, and discipline. So to what extent these are also applied at the regional level, building up anticipatory tools for unexpected, unfortunate big-scale events. Please, Carl.
Thank you very much for inviting me and recognizing also the important contribution of the local and regional levels to all dimensions of the EU better regulation agenda. The Committee of the Regions takes its responsibility in this area very seriously, and we appreciate if our efforts are noted, so as it was done in the recent European Commission report on subsidiarity. Indeed, it is very important to recognize that the European Union has also a third dimension. We have the European level, we have the national level, but we have also the regional and local level. And perhaps this level is one of the most important one, because it is the only one where people live. And in their villages, in their cities, in their regions, they decide finally if they consider the European Union as a fear or a hope. And the added value of European activities must be understood and also concretely organized on this regional and local level. As we have heard already from different speakers, the noble aim of making EU regulation better, more resilient, more future-proof needs all hands on deck. All instruments at our disposal need to be used, and we need to coordinate what we do as closely as possible. We know, and we have known for a long time, that not just EU regulation needs to be better, but EU policy and policy making must also become better, particularly in times of crisis. And we also know that this is sometimes very difficult because our instruments are not perfect, and we have seen it also in the Conference on the Future of Europe. If we will make really fundamental changes, then we have also the need to change some things in the treaties, and that is a little bit on these times a mission impossible. And finally, in 22, unfortunately, we live in a new era since 24th of February, when work came back to Europe, and the EU urgently needs to find the solutions of the many problems we are facing at the same time, from defending democracy to securing energy and fighting climate change and social inequalities. Of course, in all dimensions, our policies need to be as forward-looking and as future-proofed as possible. But I must also add a word of caution. We have to accept that we cannot foresee the future, and therefore our policies and our instruments also need to remain flexible and adaptable to changing circumstances. Rigid and mechanical approaches, so as one in, one out, that will be discussed later today, may not always bring the best results. And learning from the past is not the only, but still an important element of making policies and regulations better. The Committee of the Regions has therefore been working for a number of years now on backward-looking and on forward-looking elements of better regulation, looking back at what works and what doesn't work in implementing existing EU legislations through our regional hub network and the closely related work in the Fit for the Future platform, looking forward in how new proposals may affect the principles of subsidiarity and proportionality. We have also started to reflect, notably through our cooperation with the European Parliament, the Joint Research Council, the European Commission and other institutional partners in the European Strategy and Policy Analysis System, better known as EPRS, on how we can tap into the foresight potential of citizen regions. This is another important element of better regulation. It is not about predicting the future, but being prepared to different possible futures, which means, again, to have adaptable regulatory tools to try and shape the future and be ready to adapt to it. And so, as it was said in the document elaborated by Mrs. Gauck some years ago, foresight is to the future what memory is to the past. An organizing, selective principle creating order in complexity. I find it was a very good formulation in this document. In this context, allow me a remark which may seem a little bit cuisine interne to you, but which I think is important for our discussions today and for the contribution of the Committee of the Regions. Our Bureau decided in June to create what we call our Better Regulation and Active Subsidiarity Steering Group, BRAS-G. And with this BRAS, we want to play a new tune for the COR, which brings together all existing better regulation elements we are working with, because we have to look backward and forward and make sure that we gather and provide the best information from the ground to the European legislator. And we will start this activity concretely the 11th of November during the next subsidiary conference in Valencia. When I spoke to the European Parliament's Jury Commission in April this year, I underlined that we take an important lesson from the Conference of the Future of Europe. There is a strong will and an expectation by EU citizens for EU democracy to be strengthened. This will be even more important when we look at the existential decisions we have to take to face during the various crises. And I hope that the conclusions of this conference will be really taken into consideration, and I hope that we can find the proof of it in the speech from Mrs. von der Leyen, the 13th of September, about the State of the Union. To meet citizens' expectations and deliver more European added value, we need to build on the concept of active subsidiarity, a concept that was elaborated by the Task Force Subsidiarity created by the Juncker Commission. This means also that we should focus the political discussions on where the real problems are. Often we should not discuss if the EU should act, but more how, to what extent, how deeply the EU acts. So about issues on the level of proportionality. It is a very important aspect. If we lose our time with the discussion, has the European Union to intervene or not, it is a little bit frustrating. The real problem, this is my deep conviction, is the question of the density of the regulation elaborated by the on the European Union level, and there we can improve fundamentally the way to work, because in some circumstances we are very strong in regulating details, and we are not able to take the fundamental decisions we need under the actual circumstances. If the current context brings any good news at all, then it may be that the momentum for important changes, so also mentioned by German Chancellor Scholz in Prague some days ago, is growing again, and we can use this momentum to strengthen EU democracy and its ability to deliver concrete results for the citizens at the same time. We have to look at these questions with an open mind. As Committee of the Regions, which is a number player in the Brussels game, we try always to anticipate what the other actors may do in order to increase our chances to have a say and to sometimes even shape the agenda. If we are recognized as having good information and useful ideas coming from the cities and the regions all over the European Union, from these 1 million elected people who are working there each day, then I am confident that we can make this work for all of us. Thank you very much for your attention, and I'm looking forward to our discussion.
Thank you very much, Carl, for your very detailed contribution. Certainly, we have the opportunity for a second round of points. Now, I would like to go to Sweden, where we have law, and the idea is what is going on in a national parliament regarding this work of anticipating future unexpected events and including this in the legislative process. Please.
Thank you very much. Thank you for inviting me. And before I start to share some of my ideas and thoughts on these subjects, I wanted to say that I enjoyed very much the first session and also what the previous speakers spoke about. Maybe I should say that preparing my remarks, I wasn't perhaps thinking about times of crisis. I know that in the first session, for example, I asked myself a rhetorical question: can you actually legislate in a time of crisis? Is legislation a useful tool in a time of real crisis? Of course, the crisis is long enough, you might be able to legislate, or you might even legislate quickly, some crisis legislation. Anyway, preparing my remarks, I must say that I started my thinking around normal times. Well, Elizabeth just told us that there is no normal times, they're just abnormal times. A very poignant point and a good point from her. But just so that I give you some background, I was thinking about what is going on in the normal sense, in a normal way, normal processes. So anyway, I would just wanted to, coming from a national parliament, I would aim to offer you some hopefully worthwhile experiences and humble suggestions on two aspects. European added value as perceived through a national parliament's subsidiarity test, so very practical, and also some thoughts and words about the value of ex post evaluation and the possibility of improving anticipatory tools through ex post tools. And this is because, of course, my work at the Secretariat means that we support all the Swedish Parliament's committees with their evaluation of ex post evaluation of previous decisions, mostly legislation, but sometimes budget reforms and programs. So first, subsidiarity testing and European added value. Sweden's Parliament, as one of the few in Europe, actually formally tests every single EU proposals. The Riksdag has an advanced and quite ambitious system which delegates the testing to individual committees. But of course, the reasoned opinion are decided in the chamber by a majority vote. The Riksdag system also makes it possible for a committee to request within a deadline of 2 weeks the government's assessment of the EU proposal's compliance with the subsidiary principle. So the idea here is that the government and the government offices are the real experts. They're involved in negotiation, so they have the deepest detailed knowledge about EU proposals. So the parliament asks the government, can you please give us your view on this proposal? How does it comply with the subsidiarity principle? And since the entry into force of the Lisbon Treaty, the Riksdag has issued no less than 89 reasoned opinion, actually, and 2 more will probably be decided in 2 weeks. And so this amounts to more than the number of reasoned opinion decided by the very active Austrian and French upper houses combined. So you could say that Swedish parliament, at least also for the first 5-6 years, were very active in issuing reasoned opinions. 2/3 of all these reasons opinion were unanimous. And somewhat strikingly, in 23%, roughly 1 out of 4 of the reasons opinions, the government's party went against their own government's subsidiarity assessment, which is in regular parliamentary life in Sweden almost unheard of. Government parties always, of course, supports a government proposal. So does this mean that the Riksdag sees less value added in European legislation than others, other actors, that it's more reluctant, less EU friendly, stricter on European value added? Well, actually, no. I would say that it has to do with the way in which the parliament has set up this testing. The system is very thorough, and actually the committees look at every single article and paragraph, in contrast to the government, which often makes a more general assessment of the subsidiary principle. Another factor here is that we're dealing with subsidiarity. If the government would say that, as Carl mentioned, if he touched upon the subject, if a government would say that we believe that this proposal is not in compliance with subsidiarity, then it would be harder for the government in negotiation to kind of how do you say, I'll scratch your back, you scratch mine, because it means that, okay, you don't want this at all at the European level. Whereas the Riksdag, the parliament, is more freer in this role. So one lesson that we should take away from this is that the way in which we structure an assessment matters for how we see on European value added. Another lesson is that we should not see European added value as a black or white or a digital concept, but rather have a scale of gray which different actors have different perspective on. However, a red thread in many reasoned opinion from Sweden is that there seems to be a longing for more directives and less regulation. So perhaps Europe needs to raise the bar when assessing levels of European added value, and shouldn't be afraid of concentrating on fewer but more justifiable and less burdensome legislation. This could, in the long run, make EU legislation even more legitimate and thus more future-proof. Now, I turn to the value of ex post evaluation. Evaluation has been a core principle of Swedish policy making. To a tradition of social engineering which has characterized Swedish politics and indeed Swedish society for a long time, evaluation has been largely used by politicians. An ex post evaluation offers some luxuries which anticipatory governance cannot enjoy. I will only give you some of the examples. You know them. I think you know them. Ex post evaluation measures certainties and can, in the best of cases, actually rely on indicators. It deals with knowns and not unknowns. It can even, in some cases, enjoy the benefits of comparative analysis. reports from the OECD or the United Nations, or of course larger international research project. And it is actually not that time sensitive. It can be triggered when the reform has had enough time to be properly implemented, so as to gather a good amount of empirical data. And effects and empirical data that we measure can be compared to the ambitions, the goals, and the assessments which were made in the legislation which is being evaluated. Of course, ex post evaluation has some drawbacks. Data may be lacking, and here I think that Elizabeth's point about having good data over the whole of the European Union is very important, and it's a challenge, but it is an important point. There are other drawbacks. Actually, sometimes clearly articulated and measurable goals may also be lacking. You have a lot of political decisions which are taken, and the goals are not really measurable, and it's more of a visionary goals. And of course, you have the problem of muddling, the muddle problem, so to speak. Other unrelated reforms of legislative decision may muddle any causal evidence on whether or not the measured effects of a specific evaluated policy were attained by this exact policy. Despite this, ex post evaluation gives parliaments exceptional potential to analyze and ultimately reshape and improve legislation for coming generations, thus making policies more future-proof. How can anticipatory ex-ante governance tools improve from ex post evaluation? Well, one possible such lesson would be that to use indicators identified as robust and accurate markers in ex post evaluation of similar and or previous legislation. My understanding is that an anticipatory policy making is hard because you have to often have less time. You have to use your imagination. But if you can rely on indicators and source and knowledge taken from ex post evaluation, which are often less time sensitive and which are which are subject to this time constraint, it can be better. And of course, such indicators could be put into legislation in different ways. Indicators can be positive. It can show green light, measuring the level of intended results. So it gives you those green lights like in a control room. Of course, negative. It can measure unwanted results like fire alarms, for example. And last but not least, if such key performance indicators can, for example, through technological advancement, be digitally designed and implemented with low cost to companies and individuals, this could give legislators and administrators real-time information, thus making legislation more future-proof, especially in time of crisis when one has to respond quite quickly. So I will end my first intervention. If there are questions, I look forward to them. Thank you.
Thank you very much, Thomas. You raised a lot of good points that I would like to use for our second round, especially the one related to the good data. Now let's go to our colleague Mina and Alexandra, who will show you what we are doing in the field of European added value, cost of non-Europe, and stress testing. Please, Mina.
Thank you, Lauro. The European Parliament has a keen interest in anticipatory policy making. Alexandra and I work in a unit that supports the committees with forward-looking studies that can help set the political agenda. We offer two core products, one of which is the Cost of Non-Europe reports, and another is the European Added Value assessments. Both of these products look at the current situation and assess what could be gained with more EU action. We do this through legal and economic analysis. Where possible, we try to quantify the potential gains. Many forward-looking studies, including ours, assume that the future will evolve according to expected trends. For example, the population will age, our systems will become more digital, and so forth. But what if a crisis hits and shifts the future in an unexpected direction? What if we could avoid such situations? There have been crises, and there will continue to be crises, as other speakers in this panel have mentioned. So the answer is our legislation needs to be ready. This is what motivated the European Parliament to launch the stress testing project. This project was already underway before the COVID crisis hit Europe. Our goal here is to develop a stress testing product that the committees at the European Parliament can request to identify weak or missing points in existing or proposed legislation. The stress testing product could also find gaps that could be addressed by EU-level initiatives. The stress testing approach should be flexible, it should be fast, and it should focus on legislation, because this is where the Parliament can intervene. We are making good progress. We published our first study, How to Stress Test EU Policies, which is in the link. We published it early this year, and now we are carrying out a stress test of EU rail policy. Alexandra will take it from here to tell you what the first study achieved and why rail policy was selected for the current exercise.
Thank you very much, Mina, for handing over. So indeed, the first study on stress testing developed a methodology for the European Parliament on how to stress test EU policies. And the approach brought together two lines of work, strategic foresight and legal analysis that are rarely analyzed together. And the study showed that stress testing done in such a way indeed can bring value to policy making in the European Parliament. And as a next step, we envisaged to carry out stress testing exercise on one EU policy area, as Mina said, and we picked rail transport. Why? So first, because rail is central to the transformation of transport and mobility and the delivery of the European Green Deal, which is a key priority in this legislature. Second, rail transport is a tangible and well-defined policy area, and which also is very rich in data and evidence. That could allow us to checking for some quantitative impacts of different scenarios along the qualitative impacts. The starting point of our work was the Commission's Sustainable and Smart Mobility Strategy, which sets the vision on how to achieve green and digitalized transport and mobility in Europe. The strategy is structured around 10 priorities and that are organized under 3 objectives of sustainable, smart, and resilient mobility. We selected for our stress test one flagship initiative to be analyzed from each of those 3 objectives. And we will be stress testing selected pieces of EU rail policy that are related to delivering these 3 flagship initiatives. And the test will be done against 4 types of shocks, 3 types of shocks actually. So an environmental, technological, and geopolitical shock. And this shock would allow a reflection on how EU policy in this field is prepared for unexpected futures. For this rail policy stress test, we are working together with the colleagues from Secretariat of the Committee on Transport and Tourism. And we are midway through. We expect to publish results beginning of 2023. And at this time, we hope that that stress testing product will be ready to launch in the European Parliament, and that the committees of the Parliament will be able to use it. Still, there are challenges and unanswered questions we are facing in this project. For example, how we can best engage policymakers, so in our case, members of the Parliament and their staff. How can such a stress testing exercise be carried out in a short period? How can we avoid creating another layer of work and still contribute to the quality of EU policymaking? How can we ensure coordination also with stress testing efforts in other institutions? So many questions, and we look forward to the discussion in the panel. Thank you very much. We welcome your ideas, of course, and feedback, so waiting for questions.
Thank you very much, Alexandra. Thank you, Mina. I would like to recall the audience if they would like to raise any questions, so do it using our question and answer or the other tool we have applied today. I would like to exploit our discussion panelists to use them for a second roundtable, and starting from one single point, because we have touched until now a lot of different subjects, from impact assessment, European added value, foresight activity, regional dimension, and national dimension, and so on. But since we are here in the European Parliament, I would like to ask you one question. So, according to your experience and what we have discussed today, what is your suggestion the European Parliament should do to improve its legislative process in light of having in mind this future thinking, flexibility, unexpected shocks, and so on? Elizabeth.
I think that in this discussion about division of responsibilities, I think overall we only have so many resources. So I think we really need to find common purpose and to use the resources that we have for analysis in the best way possible. So how you ask, how can EPRS or how can Parliament improve what it's doing in order to support the lawmaking process? Now, I think you do some very useful work in terms of scrutinizing impact assessments. When I thought about your work on stress testing, I was thinking about how could you usefully integrate that into the lawmaking process. It's very difficult ex ante. When the Commission is doing impact assessments, it consults and so on, but it's still at a point in time where the Commission as a political body has not yet taken decisions. But I think, so there, I think the input is more difficult. But once the Commission has issued a proposal, you can certainly yourselves there say, well, was there sufficient attention paid to foresight? Was there sufficient attention paid to the vulnerability, stress, whatever? There you could usefully do your stress testing. Secondly, on evaluation, you do a very useful evaluation rolling plan. And I think there, when you look at evaluations coming up, I think you could usefully say, well, we think that these pieces of legislation, we've looked at these pieces of legislation, and we think that they're not terribly future-proof, or we think that the vulnerabilities or stresses should be looked at in more detail in this regard. So I think there, it's a question of selecting where you have your inputs and targeting them so that they're actually useful and can be used in the policy making process. I think that any foresight exercise certainly complements the policy preparation process. It's useful inputs. I think the value-added assessment, when you assess EU value-added, when you look at the cost of no Europe, that's certainly a very important input into setting priorities. So I think that there are places and there are, shall we say, strategic points in the policy-making cycle where the Parliamentary Research Service can make a very targeted and useful impact. And I think there we have to work together as administrations of the institutions to make sure that we make the best use of all of our resources. So I'm not sure that answers your question directly, but that would be my suggestion.
Thank you very much. Yes, in the meantime, we have received one question, but please let's conclude our first and second round with Carl, please.
It's a very tricky issue, but I think that the most important thing is that every body has to maintain in his mind that things must be seen from the perspective of the European citizen. And the final decision will always be what is the added value of a European decision on the level of the citizen there where they are living. And that is something what we often forget in our European bubble in Strasbourg and Brussels, and we must come back to this each time. And it is very important to use all scientific tools, instruments, assessments, stress tests, and all things you want to improve the quality of our work, but it must always be in the direction of the added value from the citizens on the ground. And there we have a fundamental problem, a kind of mission impossible. The European decision-making process is something what I often compare to a Bermuda Triangle. Commission, Parliament, Council, and then this secret trilogue strategy. That is not the best way to make democracy, but it's the only way we can do today, because these are the treaties. We must come one day out of this kind of decision-making process to a more classic democratic decision-making process. But today, we don't have the possibility, and we must solve our problems today with the instruments we have on our disposition today. And that is not always easy. And so I think that all approaches done by the experts, by the research centers, by everyone who is concerned by this question of better regulation is very, very important, even if in the end of the day, we will still remain with some frustrations.
Thank you very much, Carla.
Thank you very much. Interesting question, and the remarks which have been made are very interesting already, made by Elizabeth and Carl. Maybe I would just ask, let's be practical. If your question was, what advice do I have to the European Parliament? And in my way, if something has been delivered by the Commission, my way of thinking, if something has been delivered by the Commission, a proposal, and it passes the subsidiarity check, which the national parliaments make, then you have, and it arrives on the table of the legislators, so the Council and the European Parliament. You have kind of passed the value added test. You have a product to work on it, but you must still take care of it, because you have this interinstitutional agreement between the three, as Carl mentioned, the three actors. And we know that every proposals, basically every single proposal which comes from the Commission changes a lot or a little bit, but often a lot. And when you change it, something which the interinstitutional treaties and international agreements points to it is that you have to be careful and not to change this too much, so that you actually go from a green light in subsidiarity terms to an orange light. that you change this legislation and make it too burdensome, or that you lose some European added value. So that's perhaps one advice I would give you. And the second is I think I will return to what I said earlier. It's important to focus on goals and less on the means. Perhaps, I mean, of course, if you have a proposal for a regulation, it's hard to change into a directive, but try to set the focus on the goals and not the means, because the European Union, while it is a union, it works very differently in different member states, in different regions, and not to allow for this regional and national creativity to take place, I think might hamper more, might do more damage than good. So anyway, just some suggestion.
That's really interesting. We try to take and to maintain this in our minds for our daily work here. In the meantime, we have received a couple of questions. The first one is from Eckhard Sturmer, who asks, with foresight instruments in better regulation, this is reacting to the policy issues that are selected at the very front end of the policy design phase. Don't we need to use forward-looking at the topic selection step to help be prepared for the abnormal of upcoming disruption and crisis? What are your proposals to make this happen at European and member states level? I hope this question has been clear, and who would like to reply among our panelists? Elizabeth, maybe?
I think that in the many initiatives that are being taken right now, you have scenario planning going on, you have horizontal scanning going on. So I think that the Commission and the Joint Research Centre, Parliament included, are looking at future scenarios and trying to identify where policies need to be changed, or where policies need to be adopted in order to be fit for the future. So I think there's a lot of activity going on there, and certainly that should influence what I think is important. These foresight exercises should influence the planning process, so that we're not operating with tunnel vision, but we see the broader picture. We cannot predict the future, I don't think that, but at least we should let these exercises inform the planning and the policy preparation process.
I have to leave now. I apologize because I have to chair a meeting in 2 minutes in my parliament here.
You're right. It's also running
very
for
happy
us.
to be with you, and I hope that we can continue our discussion in the future. Bye-bye, and I wish you a very good end of the meeting.
Thank you, Carl.
Thank you very much, Carla. To summarize, we are approaching to the end of our session. We have received a couple of questions, one from Petra van Nierop and another question from another participants regarding our study on stress testing. So I would like that we reply bilaterally to these two questions, so to be more complete and more detailed. So don't hesitate, we will contact you to explain more in detail what we are doing. There is just another question, and then we can close our session. That is from Prof. Ellen Xantaki, who say Mr. Lambert is absolutely right. Better regulation can only be citizens-based and citizens-facing. How about user testing? How about user-friendly legislative language? COVID has taught us that citizens comply with legislation when they are able to understand why it is introduced. And second, what exactly they need to do. What can we change EU legislative text to share clearly and in a user-friendly way these two crucial types of data? Who would like to reply to this question?
Sure, I can reply. I think it's one of the, the biggest challenges of EU policy making is to make our legislation and our policies and our communication generally understandable. In the Commission, we had many KISS exercises, keep it simple, straightforward, simple. And I think it's very important that citizens be able to understand what we're doing. How can we involve users in the process? I think that here, I go back to what Thomas said about evaluation. We need to involve citizens in discussing the evaluation, discussing the legislation we have. Is it working? We need to be much more flexible in our monitoring and assessment exercises, that we can include citizens in ongoing assessment of EU legislation. So I think that is a challenge for the future, building up our evaluation processes so that they're relevant, timely, and involve user input.
Thomas, you would like to add something?
Just quickly, I agree totally with Elizabeth, and it's an interesting question. I believe in the fact that all language should be easy for citizens to understand. This applies to legislation also. However, so I think that the Professor Helen Xantaki makes a good point and an interesting point. However, perhaps one Achilles heel to having a simple legislative language is the complexity of our societies and the complexity of different values which are often clinching in legislation, and we try to deal with this, and sometimes it takes us to text in a way of structuring legislation which is complex. And this is why we afterwards have a lot of different authorities on the national levels who try to break down this complicated legislation and give brochures and information. For example, I try to build a patio with wood outside on my summer cottages, and the rules are very complicated. But the national agency in Sweden, which is responsible to it, gives me a brochure which is really simple. It simplifies a law text which is, I mean, just 35 pages long, and it gives me a simple schematics. This is how you can build your patio. This is how you cannot build your patio. Just so in one way, she has a good point. Legislation should be user friendly in the language, but we should also not refrain from actually dealing with complex issues and classes of values in legislation. And if it's too complicated, let other communicators sort this out. I don't know if it makes any sense what I just said, but I hope.
Thank you very much, Thomas. I see Alexia, my colleague, approaching, starting to moderating our third session today. So I would like to conclude our session here. I would like to thank Elizabeth, Thomas, Carl, who left us, and Mina and Alexandra for their great contribution. Thank you very much. Our participants, thank you for having been so patient to listen to us. And how the two questions we have not replied, we will do this bilaterally. And now I will leave the floor to Alexa for the third panel. Thank you very much.
Thank you.
Thank you very much, Lauro. Good afternoon, dear distinguished speakers, dear colleagues, dear participants. I'm really happy to welcome you to this third session of our conference on implementing the one-in, one-out approach, more cost than benefits, ? I'm Alexia Maniaki-Griva. I'm the head of the Ex-ante Impact Assessment Unit in the Parliamentary Research Service, and I'll be the moderator of this session. Our conference today focuses on forward-looking policymaking in times of crisis. We heard in the previous two sessions about the key challenges and opportunities for the EU's better regulation agenda, as well as new tools for future-proof legislation. Session 3 will now zoom in on the one-in, one-out approach for burden reduction that was recently introduced into the better regulation agenda. With this approach, announced by Commission President von der Leyen when she took office, the European Commission aims to offset newly introduced burdens by relieving citizens and businesses of equivalent burdens at EU level in the same policy area. Introducing this approach represents a U-turn in Commission policy, as we also heard from our rapporteur earlier, and was indeed a surprise to many. Many stakeholders have expressed reservations regarding the one-in, one-out approach, including the European Parliament. As the Parliament's rapporteur, Mr. Wilken, said earlier, the Parliament was critical, and he's personally skeptical. In its July resolution, the Parliament pointed out that the implementation of the approach should not affect political imperatives or the objectives of better regulation. The one-in, one-out approach was piloted in the second half of 2021 across 10 legislative files, with full implementation foreseen in the 2022 Commission Work Programme. The results of this pilot project were set out in the 2021 Annual Burden Survey, which was published in July. Our session today aims to discuss how the Commission envisages to implement the approach, the underlying methodology, and the lessons learned to date. In particular, it will aim to discuss the related costs and benefits, and risks and opportunities. I'm delighted to kick off the discussion with a distinguished panel of speakers. First, we'll hear from Mrs. Katharina Einheiter, who is a research assistant at the Institute of European Law at the Johannes Kepler University in Linz. Mrs. Einheiter contributed to a study on one-in, one-out in 2020, led by Professor Leidenmüller. She will share with us her academic perspective on the approach and its implementation to date. As a second speaker, we're pleased to welcome Mr. Rytis Martikonis, who is the chair of the European Commission's Regulatory Scrutiny Board, which is the independent body within the Commission that checks the quality of all Commission impact assessments and major evaluations. The board is not responsible for policy design, but it has a scrutiny and advisory function, including with regard to the one-in, one-out approach. We're eager to hear from Mr. Martikonis what the approach implies in terms of methodological adjustments, which were also set out in the annual burden survey, and how the board is keeping tabs with the approach's implementation. After those more practical insights, we will turn to the stakeholder perspective and hear from those who are meant to be the main beneficiaries of the approach, namely businesses and citizens. Our third speaker is Mrs. Veronique Willems, who is the Secretary General of SME United. Finally, our fourth speaker, Mrs. Isabel Schumann, could not make it today, but we will hear from Mr. Joachim Smedman, who is legal advisor in charge of better regulation at the European Trade Union Confederation. After the speakers' presentations, I will open the virtual floor for discussion. Please feel free to put your questions in the chat or Q&A. I'm now very pleased to give the floor first to Mrs. Einheiter. Mrs. Einheiter, please.
Good. So what is the one-in, one-out principle? Some information has already been provided. So the one-in, one-out principle is a deregulatory concept. Its aim is to reduce administrative burdens. Some EU member states and also beyond the EU have already implemented or are planning to implement the one-in, one-out principle, sometimes under another flag, like cutting red tape or the like. As various studies show, the implementation differs in degree and also success. When it comes to the one-in, one-out principle on EU level, in the past, Commission was rather reluctant with implementing this concept. In 2017, the Juncker Commission stated that rigid deregulation targets like the one-in, one-out are a misguided. With the von der Leyen Commission, the rather antipathy has changed. The one-in, one-out principle should now be an instrument for burden reduction. Initial guidance was provided in the Commission communication of April 2021, complemented by the better regulation guidelines and toolbox, which provide further information on operational and methodological details. The one in, one out approach is policy-based. That means burdens will have to be offset within the remit of each DG. If not possible, then within the refit area. And if that is not also not possible, then the costs will have to be offset within the broader policy area, like our European Green Deal, Europe Fit for the Digital Age, etc. Furthermore, it is burden-based. That does not mean an act for an act, but offsetting burdens with savings in the same policy area. Which burdens are meant? The Commission's one in, one out approach covers compliance costs, which are costs that need to be borne to comply with the provisions. More specifically, administrative and adjustment costs should be addressed. And the reporting period is 1 year and has to be done in the annual burden survey. Now to some critiques. The one in, one out is drawing some criticism. From a general perspective, the one in, one out treats the existing regulatory level in a certain sector without any empirical basis as a perfect baseline. Some sectors may indeed be over-regulated, but some may even require more regulation. Climate change, pandemics, digital transformation, so new legislative challenges lie ahead. The policy-based approach risks a blockade of the development of entire policy areas due to the tight cost constraints that are imposed on policymaking. Legislative bodies will get under deregulatory pressure. Political criticism comes also with the focus of the one in, one out, although the Commission stresses that individuals and businesses should benefit from offsetting burdens. Due to the connection to the refit program, they even say refit is complemented by the one in, one out approach. A focus on burdens on businesses is undeniable. The criticism that goes along with this is that standards of social protection are reduced to a cost factor for enterprises. But the burden reduction approach ignores the social benefits of it, like protection of workers, consumers, environment, or the public health. There is a potential risk of lowered standards of social protection, but also macroeconomic multiplier effects are not taken into account. That a new law increases demand of certain goods or services which create value in another industry. Legal framework in democratic societies should always be maximization of net benefit for society as a whole. But there's also some legal criticism. Primary law requires EU institutions to strive for higher level of protection concerning health, safety, environmental protection, consumer protection. Prominent provision is in this respect Article 1140. There is a requirement of taking account of any new development based on scientific facts. There's a requirement for continuous improvement of standards. A strict one in, one out on a sector by sector basis would prevent future improvement in the level of protection in the respective fields. So, well, when we look close at the concept, the Commission included some arrangements that make the concept more flexible, like flexibility within the reporting period, flexibility across policy areas, and exemptions in exceptional circumstances, like to fill a regulatory gap. From a social point of view, it is highly welcomed, but regarding the one in, one out, is it fraudulent labeling in the end? What remains of the one in, one out? Do we really need such a tool? Thank you very much for your attention.
Many thanks, Mrs. Anreiter, for this overview of the approach itself, but also of the criticism that some of your criticisms, I believe, are also shared by other stakeholders. We'll now move on to a more, let's say, practical insight as to how this has been actually been implemented in the Commission. We know it's been extremely challenging. The annual burden survey refers to a major methodological adjustments going on in the Commission to actually implement the approach. Now, we read about the results of the annual burden survey of that pilot exercise, and the board has actually seen the impact assessments that actually report on the cost estimates on which this approach is based. So we're happy to hear now from Mr. Matikonis the more practical perspective of how things have been going on and how the board is actually checking the approach. Mr. Matikonis, the floor is yours. Thank you.
Thank you. Thank you very much. Thank you for your introduction, Alex, and also for your service in organizing such an event. I'm glad to hear and to listen from the beginning that RSB is being mentioned from the very beginning, both in positive and more critical terms. But I have to start with a couple of more general remarks in that sense, because the board's mandate was renewed for the von der Leyen Commission by the adoption of the decision reaffirming its internal role in supporting the implementation of the Commission's better regulation commitments. And the board does not, I would say, never questions the political objectives and choices presented in the reports accompanying draft proposals, but considers the quality of evidence, analysis, and logic of intervention. What is important in this to emphasize, once again, that RSB is part of the Commission's internal quality assurance system, and it focuses on implementation. Also, to echo the very first intervention of this event, RSB is fully accountable to the President and the Vice President of the Commission, like all the other services of it. And in its deliberations, RSB does not seek or take instructions from anybody. And in that sense, it is really an independent body. Now, regarding the outreach and transparency, I believe we follow the highest standards because all RSB opinions are published together with the Commission's decisions, and all external meetings, not only of the chair, but also of the members of the board, are registered and available also on our site. Needless to say, members of the board never discuss particular files with the interest groups or organizations. Now, turning to one in, one out, I would do perhaps 2 or 3 iterations of zooming in, but let me start with placing this approach, one in, one out, into a bit broader scrutiny system that we do. One in, one out is part of the comprehensive assessment, is part of the scrutiny, and it is always treated in combination with other elements. As colleagues perhaps would know, the scrutiny of impact assessment is structured around a number of topics, from context, scope, problem definition or subsidiarity, as just talked a while ago, to future monitoring, evaluation, and presentation. One in, one out, related information is fed into the parts on impacts, comparisons of options, and proportionality. And to put one in, one out angle into the more operational context, I can only quote some of the leading questions, or sort of questions that guide us at looking at this particular part of impact. And to start with, we would always put the question, is the analysis of impacts proportionate and balanced across economic, social, and environmental dimensions. Our conclusions clear and reasonably based on qualitative and quantitative evidence. Have relevant specific impacts, including on fundamental rights, member states or regions, consumers, and so on, been assessed, including indirect and possible unintended consequences. Contribution to United Nations Sustainable Development Goals, have they been identified? And only then, you see, we come with the regulatory cost and benefit. Has this been identified in an exhaustive way? Are they quantified? We would go then to business competitiveness and SMEs, no doubt. As the colleague just said, to continue to zoom a bit further, one in, one out mechanism covers compliance cost. Compliance cost made of administrative and adjustment costs. I would not go into the definitions. We can always discuss the scope, but the previous speaker, I think, rightly alluded to that. What is important from our perspective, from RSB's perspective, we are looking at the quantification where feasible and proportionate. I have to also make a caveat to what you also said, Mrs. Moderator, that RSB is involved in scrutiny of evidence and quality of impact assessment, and we are not really doing the balance sheet, of what is in, what is out, what is offset, or what is compensated. The responsibility for this is with the policy DGs and Secretariat General of the Commission, which is in charge for an overall better regulation policy in the Commission. But what RSB does, and here I zoom even further, when we look at one in, one out, in terms of quality of evidence and analysis, I have 6 or 7 quick bullets which guides us always in this work. The first one is the scope. Whether all costs and benefits in scope have been identified. Second, whether the identified costs and benefits in scope of one in, one out are quantified to the extent possible and proportionate. The third one would be checking whether analytical approach for the cost benefit analysis is appropriate. Normally we refer to standard cost model for administrative cost and benefit. Fourth bullet would be on robustness of validity of the assumptions and data used in the analysis, already referred in previous interventions. Fifth would be the analysis whether it reflects significant risks and uncertainty in the evidence and key assumptions used. Last but not least, once again, whether the quantified, if the cost and benefit in scope are not quantified, we are looking whether this is reasonably justified and cost and benefits are described in qualitative terms. So on the factual side, and here I can only refer to a regulatory scrutiny board annual report. Now we contribute less to burden survey, but we produce every year annual report of RSB. We can see, and we stated, we did observe that quantification of benefits and costs did continue to increase in 2021, for example, and a vast majority, around 90% of all impact assessments included at least a partial quantification of benefits and costs, with around half of them being quantified fully. We welcome that, and we also observe that wider economic benefits like GDP growth, employment increase, or productivity growth are often assessed with economic modeling. Many non-market benefits, already also mentioned in the previous session, like health, environment, are often expressed in physical units. We very often talk about the emission savings expressed in million tons, etc. Monetization of non-market benefits also happens when the values can be linked to market prices. And for example, the air pollution, reducing crop yields does allow for relatively straightforward monetization. It's also clear and obvious that other non-market benefits, such as improvements in protection of fundamental rights, social cohesion, international stability, are less straightforward to measure and often assessed qualitatively. And in that sense, knowing about this part of the discussion for the RSB, we recognize both methodologies, quantitative and qualitative, being used to assess the impacts, of course, depending on a number of factors such as nature of the initiative, proportionality, or data availability. Numerous other elements can be linked to when in, when out. I would stop here. We can discuss proper consultations of the stakeholders, as mentioned before, data granularity, and so on. But at this stage, my summing up is that in RSB, we take when in, when out as part of an integrated impact assessment. It is never treated in isolation. It is never mechanical. And by doing that, RSB does contribute to quality assurance of decision-making in the Commission, together with other services, trying to ensure that as complete and as comprehensive information and evidence as possible is provided to the College where political decisions are taken. Thank you very much. Looking forward to hear from other members of the panel.
Thank you very much, Mr. Matikonis. Thank you for these insights into the board's work in regard to one in, one out. We'll go on now to our stakeholders who are with us, and I'll give the floor to Mrs. Williams from SME United, who will share with us the SME perspective actually on the approach, and then Mr. Smedman. Thank you.
Thank you, Alexia, also for inviting me to this interesting discussion. Maybe from an SME United perspective, I would like to first give a general reassurance, because it was already mentioned. I think that Mrs. Arnreiter immediately started with saying that the one in, one out approach is a deregulatory approach. According to us, it's not the case. One in, one out is not a deregulatory approach. And as such, we also don't see or question it or ask for it in that perspective. Because in general, SME United supports that rules are necessary to organize our society. We even ask for regulation in certain fields, and I would like to refer to one example. For instance, a platform to business regulation is a piece of legislation that we have explicitly asked for ourselves as an organization. However, we do advocate for rules to be efficient, effective, and proportionate. And there we often question, and especially also during this mandate, whether the EU legislative focus isn't too much on putting in place reporting on change rather than really reaching a clear change in reality. That focus on more of the instruments rather than the objective could also be detrimental to really reaching the objective that the legislator has in mind. I'm thinking about the risk of greenwashing. I'm thinking about creating a lot of reports and risks analysis rather than focusing on safety on a construction site, for instance, in the facts, in reality. Moreover, we also would like to raise the cumulative effects of legislation and the increasing complaints across society and across different parts of society on high regulatory burdens. And then I don't only think about SMEs. I would also like to refer, for instance, to local authorities, teachers, and so on, who also raise more and more the fact that they are drowning in more the administrative elements of a task, rather than being able to focus on what they really should be doing. And in that perspective, we have stated already from the beginning that according to us, the one in, one out is not enough to lighten the load, especially for our SMEs, but rather leads to a status quo. And if we really want to decrease the administrative burden for SMEs, we have to apply what has already been done in several countries, by the way, one in, X out meaning more than one out. And in the consequence, we also don't have a lot of high hopes for the impact of the one in, one out approach, certainly not in this mandate, given that it has been only implemented on new initiatives in 2021, whereas we see that a lot of initiatives have already been published 2020, 2021. I would like to advocate for a one in, one out, or a one in, more out approach, because we do see that it can have positive effects. A CEP study has indicated, for instance, that Denmark, who has long been working with a one in, more out approach, ranked first in a global sustainable development goals index. So it's not proven that with a one in, one out approach, you would have a detrimental effect on social or environmental standards. And according to us, also to allow the twin transition, you need to clean up your regulatory framework, because the current instruments in place might not always allow for companies to make that transition to the digital and green economy. So those are a few elements that I would like to put forward in the discussion. Looking at the annual burden survey and the first evaluation of the pilot projects that have been conducted by the Commission, and I'm also curious to know the view of Mr. Martikonis on this, because it was stated that the level, or that we see that there are several increases in the number of quantifiable elements in impact assessments. We still have a serious concern on the quantification on impacts on SMEs. And we still don't see that those elements are sufficiently taken into account in impact assessments. That's one thing. Secondly, what we also lack is on several initiatives that a decent impact assessment is being produced. Giving one example, very recently on the forced labor ban on products. So those are all elements where we have serious concerns. Additionally, we would also request the calculator to be transparently available during consultations and in the impact assessment, because that would also increase, again, the buy-in of different actors and stakeholders. And we would also call again, and that's not the first time we do this, for a good planning of consultations so that stakeholders can also ensure a meaningful input and try to support also that quantification of impacts as much as feasible for them. Making also the link as a member of the Fit for the Future platform to Refit and Fit for the Future. I think those are all elements that can be put together in the puzzle, and that can contribute all together to having a smart regulation, as we are calling for. And in that perspective, I don't completely agree with what Mr. Now I forgot his name. Mr. Wolken said in the beginning that we are losing resources here in the one in, one out approach to be dedicated to other elements. We have had those resources to produce good legislation in the past few years, and we have seen that for SMEs, this has not been the case. We have been advocating since 2008 for a think small first principle and act accordingly, and not only think, but also show in legislation that you have thought this through. And unfortunately, we haven't seen this applied. So the only way out at the moment to reduce burdens for SMEs would be a one in, X out approach to really mitigate the impact of administrative burdens. And I'm really now referring to the whole regulatory burden, compliance and administrative burdens. And we call also for taking into account reaching the objective and how you reach that objective. So that's a bit our thoughts at the moment.
Many thanks, Mrs. Willems, for sharing with us the SME perspective. I'm sure take this back into the Q&A, but first I'll give the floor now to our final speaker, Mr. Smedman, who will share the European Trade Unions Federation views on the approach, and we'll then go into the discussion. Thank you.
Thank you very much, and good afternoon from my side, and apologies once again on behalf of Isabella Sherman, our Confederal Secretary, who can unfortunately not join today, but with whom we work closely on the better regulation agenda as part of a long-standing track record of the ETUC actively engaging in the discussions around the implementation of the Commission better regulation agenda, where I must say we have taken a quite critical stance on the one in, one out approach, and we try to act as a counteracting force against what we see as a quite reductionist approach on regulation in terms of cost and burden reductions only, where we wish to promote a more positive narrative around quality legislation in the general interest beyond purely economic interest, and with a clearer medium to long-term vision also, because clearly business interests alone cannot be put on an equal footing with the general interest, which also includes the interests of workers, citizens, consumers, the environment. And mainstreaming the sustainability goals in EU lawmaking actually requires economic, social, and environmental aspects to be considered with the same level of importance, detail, and accuracy. But in our view, this is clearly not the case still today. Regulation can, of course, bring economic benefits, but also social and environmental ones. And conversely, also non-action or the lack of enforcement can result in particularly high social and environmental costs, or even unfair competition among businesses. So the fact that social and environmental costs and benefits might be more difficult to estimate does not make them any less important. We believe that this quite econometrical understanding and approach by the European Commission often leads to quite shallow considerations of, for example, the impact of human rights in their impact assessments. And also, clearly, the outcome will be very much dependent on the variables used and looked at. And as quite rightly pointed out by MEP Vulcan at the beginning of today's seminar and underlined in the Parliament report on better regulation from earlier this year, the whole issue of the one in, one out was something that already the Juncker Commission expressed quite clear reservations on, as it would, as the Commission put it, create deregulatory pressure and impair its political responsibility to deliver what needs to be done when it needs to be done. But still, this is something that has been quite unilaterally introduced by the von der Leyen Commission without any consultation of the Parliament and prior impact assessments, which in our opinion goes quite against the Commission's own better regulation principles. Well, now, supporters of the one in, one out would of course point to the dedicated pilot project that has been conducted and the results that we now have on the table. But for the TUC, many of the findings that we see in this year's annual burden survey, in our view, confirm the criticism of the one in, one out. I'll give you a few examples. While the TUC advocates for more qualitative considerations in EU lawmaking, the one in, one out seems to have pushed the Commission towards an even more reductionist approach. The report, for example, highlights, quote, changing practices towards increased quantification. And the TUC considers the Commission approach to be quite far from objective and scientific in this regard also, because, for example, the one in, one out calculator does not, for example, consider costs and savings of national, local, or regional autonomy authorities. We can also read from the report that estimates of adjustment and administrative costs are simply assigned to the base year in which the proposal is adopted by the Commission. And similarly, the estimated costs relate only to the Commission proposal, not to the final EU regulation adopted, or depending on how member states transpose, implement, or enforce it, for example. And in fact, this is only quite natural, since lawmaking is not in the end a scientific exercise, it is a democratic process. And in this context, it should of course be recalled that member states may also even go beyond minimum standards when implementing EU law. So for DTUC, quality regulation is an investment into the future, whereas it's quite clear from the one in, one out that it merely focuses rather on the short-term burden and costs. And once again, the report clearly acknowledges this focus on, quote, costs that in most cases can be estimated, once again, thereby favoring economic considerations over the social and environmental ones. And as a consequence, quantifying benefits has generally been harder, the report admits, but it does not really reflect any further on how this impacts the overall assessment or what could be done about it. Benefits that cannot be monetized, for example, when it comes to well-being or sustainable development, simply seem to not be taken into account under the one-in, one-out approach, especially not the long-term ones. So in the opinion of the ETUC, all these supports our view that the one-in, one-out is not really an appropriate tool for the elaboration of EU law as a multi-level governance system, because it reduces EU regulation to a kind of bookkeeping exercise, as if democratic lawmaking was some kind of zero-sum game. One could ask, for example, should compliant costs of business be taken into consideration even when a legislative initiative, for example, serves to tackle unfair competition or an abusive business model? I'm thinking, for example, about the Platform Worker Directive. Final point, on the inbuilt flexibility of the one-in, one-out, this is, in our view, something that seems to, once again, kind of covered up a flawed or inappropriate approach, because according to the Commission, a legislative initiative could be exempt from this one-in, one-out mechanism, for example, in emerging areas where it is necessary to fill a regulatory gap. But in our view, such an approach gives kind of the impression that there could be some kind of baseline or upper limit to the EU acquis within a given policy area, something that, in our view, is completely at odds with fundamental objectives of, for example, social progress, or even the ever closer union set out in the treaty. So all in all, from the ETUC side, to deliver on EU flagship initiatives such as the Green Deal, the European Pillar of Social Rights, Sustainable Development Goals, we strongly believe that we need ambitious investments, both in terms of resources and also quality legislation. So I'll leave it for here now. Thank you.
Many thanks, Mr. Smedman, for these very interesting insights. Now, I'll open the floor. Participants, please do put your questions in the chat if you wish, but we can have maybe first a second round of discussion. I mean, many points were raised. Difficulties of quantifying benefits, links with the refit. Now, I was wondering, maybe to all speakers, your views on whether you believe the approach as it stands will actually add complexity in the EU framework and will add in the end red tape, which it is actually trying to reduce. Knowing that there are also other instruments, it was mentioned by Mrs. Willems and also by Mrs. Anreiter, the Regulatory Fitness and Performance Program, which run somehow in parallel. And so how do you see the two combining and working in parallel? And doesn't, in the end, do you think we're creating some kind of an extremely complex system in the end? Anreiter, maybe you mentioned, I think, refit first.
Current lawmaking process is already quite complex. It consists of multiple layers, like consultation stakeholders that takes time, then the impact assessment, preparation, adoption, implementation, that's even intuitive when it comes to objectives, monitoring, evaluations, and so on. And one in, one out actually adds another level of analysis. And it's an analysis of costs. Costs can be estimated on a variety of sources, so they rely on data that comes from authorities, from consultation, and so on. And as the annual variance table also emphasized, is that data is difficult to obtain and data needs to be analyzed. So that's time-consuming and that can add some complexity. And since it is restricted, the one-in, one-out approach is restricted to Commission's proposals. and it's not taking into account the full costs, only the costs. And that means that changes that were made by the European Parliament or consultation with the Council in the lawmaking process that goes on afterwards, it actually does not reflect the actual costs. So why all that anti-burden when in the end the outcome can differ substantially?
Thank you. Mrs. Willems, I think you want to intervene. I see your hand. Yes.
Indeed. I think the question is not the right question to ask. The one in, one out approach has as an objective to make the legislation we make less burdensome. We don't have to make the process of making legislation less burdensome. We have to make sure that in the process, we all strive to develop good legislation that will make sure that the citizens, the businesses, know which objective to be reached, what the rules are, and to make sure that those rules are efficient, effective, that they reach the goal, and that they are proportionate. So asking whether it will add to complexity of the lawmaking process, that's then unfortunately something that we all will have to work with, because I'm really willing to make a longer process even if we can then ensure that we are not making rules that de facto are not applicable or cannot be applied by those who have to apply it. So I think that's a very important mindset change that we have to make. It's not about us, not about our process and how complicated the process becomes for us, yes or no. The objective is to make sure that we make legislation that can be applied in the real world and that can contribute to achieving the goals that we want to achieve in the real world without overburdening citizens and businesses, especially SMEs, with the laws we are making. Coming back to the element that Ms. Anreiter put forward, we don't take into account the Parliament and the Council. We are more than happy to also apply there a final check on what is feasible and maybe even extend the search for offsetting elements during the transposition period, because taking into account what OECD also put forward, a lot of elements are also added at the national level. So it's also important that at the national level, authorities get the opportunity to analyze where the EU elements in their national law are and how they can offset potential burdens that might not be necessary anymore, that are counterproductive. So in that perspective, I would say it's not the complexity of the process, it's the objective of the approach.
Thank you. Does any of our other speakers want to intervene on this point? Yes, Mr. Martikonis, please.
With pleasure. And these are important points that colleagues are making, but I would have 2 or 3 remarks. Starting with the colleague from the trade unions, pitching the general interest against the quantification or short-termism, I think is something that you wouldn't find in the opinions of the Regulatory Scrutiny Board. And I was trying to emphasize it from the very beginning that in our scrutiny, both qualitative and quantitative arguments are equally acceptable. What is important that the logic, that the argument and explanation would be there. Then when it comes to a quantification and the emphasis that has been put and a requirement that has been put to make best effort in quantifying, I think if we are talking about the evidence-based policies, we need it for a proper discussion, for proper information, both for the policymakers, but also for the public. Yeah? And it's also clear, and said by colleagues also today, that we are always talking the estimates. I mean, we are always talking the range. We are not getting at the numbers after the comma, but the reasonable indication of magnitude or the order of things that we are talking. And you wouldn't find in any of the RSB's opinions, the criticism or requirements, to put the cost on human life, or to put the cost on the stability in the neighborhood, or other non-material things that I was alluding. Then to a colleague representing SMEs, I say with the pretty strong confidence that, and open to scrutiny of our opinions, that SMEs feature very consistently in our opinions. And the SME test is sort of not to go too far, but I would say is among our favorite questions, and is, it's always checked. What about SME tests? You are also right to say that the data, that the consultation is not always perfect. And on this, again, I can only support that. Yes, sometimes by putting these questions or requesting the author DGs to go back and, for example, to provide more granular information, more granular data, is among things that RSB does in trying to ensure that we have a quality information. Then, when it comes to inputs, it's always in our purview to see sort of what comes, let's say, from the member state and from your, let's say, member associations. Sort of, since you represent the European interest, and I'm sure that both on your side and on the trade union side, you would recognize the diversity of situations across Europe, and also the challenge in making it into one coherent position. In that sense, RSB, I think, is also very consistent in asking, the as representative information as possible, both sort of on the European level, but also from the member states, also from different sectors of society. In that sense, the societal impact, the distributional effects, is also something that you would always find in our opinions. In that sense, I'm pretty confident that in our quest for quality of evidence, RSB's effort to echo what was quoted by Elizabeth Goldberg of Keynes, that I think we do pretty good job in getting approximate things right rather than precise things wrong.
Thank you, Mr. Martikonis. Mr. Smedman, would you like to intervene?
Yeah, what can I say? I believe we don't really see the added value of the one in, one out, in the sense that, for a simple reason, many benefits, especially on the benefits side, and especially when it comes to the social or environmental, it's more difficult to quantify them. So well, to put it nevertheless in econometric terms, what if the net benefits are still higher than the let's say administrative and compliance costs? How is that reflected, and how does the one in, one out contribute to drawing such a conclusion, or to building that evidence base? We don't really see the added value. And in our opinion, impact assessments are important. They should be balanced. They should take into consideration the different interests. But once again, they should not preempt the democratic debate. They should allow decision makers to take informed decisions.
Thank you very much, Mr. Smedman. I see we have a question in the chat, actually, by Mr. Friesberg, a colleague in the ex-ante impact assessment unit, because my unit is actually scrutinizing also the quality of all Commission impact assessments, and actually we're also looking now at the one in, one out approach, and actually it has been, how can I say, difficult also for us to actually determine and understand how this is appearing now in, or will be appearing in, the impact assessments as the approach is supposed to be rolled out now with the Commission Work Programme 2022. And my colleague is asking what will be the systematic method or procedure in the future of how one in, one out be addressed in the impact assessment. I guess this is really a question for Mr. Martikonis, who is actually seeing all these impact assessments now and might have a clearer view of what we are to expect as to in impact assessments.
You know, risking to sound too administrative, but to me, the toolbox is quite well developed at the moment. The implementation of it will take a bit of time, like my colleague Pascal Lardini was saying at the very beginning. After the pilot, there will be lesson learned and adjusting of it. But as to the method and procedure, I think we have it set. You know, I don't want to go into the numbers of toolbox 57, 56, 59, but it is there.
Thank you, Mr. Martikonis. I see we have one more question, and I think we'll then stop there as we are already reaching the end time of our panel. Question by Stefano Veterazzi. So his comment is, some researchers in academia have pointed out that attention would need to be given to the actual cost-cutting outcomes, which might remain below general expectations, as the administrative burdens, that is the cost to be offset according to the one in, one out approach, represent only a part of the overall cost of regulation. And he's asking, what is your opinion about this remark? So who would like to take maybe this question? Mrs. Willems?
Maybe from the SME perspective, I can only confirm that, and that's also why we were a bit critical about the launch of the one in, one out approach. As I already said, it will only lead to a status quo, because if you do one in, one out, it's not going to go down. That's already a first element. The second element is indeed you take the part of the administrative burdens, not the adjustment costs. That's an additional one. That's also what we see among member organizations. They all want to strive to harmonization, but preferably their own legislation, because otherwise their companies will have to adapt to a new situation, which incurs a cost for the companies. And for small companies, it is immediately a heavy burden. I always tell the story, and sorry to repeat it here again. 93% of all companies have less than 10 employees in Europe. The average number is 4, which means that each entrepreneur works with his or her colleagues to provide us all with quality products and services. And at the end of the day, when staff goes home, because we have a work-life balance directive in the European Union, the entrepreneur can start having a look at which rules do I have to comply with, how do I apply them in my company, and then also start implementing them. And I challenge everybody, when you are reading a piece of legislation, take a step back and think about how you would implement that in a company where you don't have a legal department, an HR department, an IT department, and so on, but you would have to do it yourself. And that's the think small first and act accordingly. Do we make legislation at the moment that is feasible for small companies to easily comply with? Because if they can easily comply with it, they will also apply it. And that's the objective that we have with legislation. And that's what we are. That's why we are also advocating for the one in, one out, no, even one in, more out. So I completely agree that probably what academia say is correct. Yeah.
Alexia, can I?
Sure, Mr. Martikonis.
The very last comment on this, that, you know, one in, one out is not the whole of the story. The refit is still there. Yeah. So one in, one out is part of the approach. Refit, and as you were saying, you participate in the platform, etc. I think it's there as an objective, and I believe also as a practice.
Thank you. So I believe we've come now to an end of this session. I'd really like to thank all our guests, our speakers, very much for this very interesting session. I think we could go on very long on one in, one out, and I'm sure this is not the end of our discussions on this topic. Now, it will certainly come back. Probably already next year, since the next annual burden survey is supposed to inform also on the results of the offsetting, which was not the case in this annual burden survey. So we'll probably get even further insights and maybe answers as to how useful the approach has proved to be or not. So, so many thanks again to our speakers and participants, and I'll now pass the floor to our Director for Impact Assessment and European Added Value, Wolfgang Hiller, who is here with us and who will actually conclude this conference. Many thanks. Goodbye.
Thank you, Alexia. Indeed, we may not just be able to talk about one in and one out for more than this 1 hour, but also on many other subjects. In fact, we covered during these 3.5 hours now a surprising range of subjects. And we exchanged views on the current state of better regulation policy and looked also to future developments. First, I would like, however, also to add to those thanking all of you for tuning in and sharing your expertise and for engaging into these fruitful discussions. Special thanks to our keynote speaker, Timo Wölken, and all the panelists for their constructive and open exchange of views. Finally, I would also like to thank the moderators and their teams for the preparations of the event and for ensuring its smooth running. In fact, I'm impressed about the engagement and high quality of the debate, including all the contributions we have seen in the chat. It shows that better lawmaking is an exciting subject and not a boring subject, as some who are not familiar with this issue may think. I was happy to note that there's a wide agreement that better lawmaking is an important factor for decision-making in a democratic and transparent way, for the benefit of society and the people lawmakers represent. We should, however, not take better lawmaking as a given. There are still many out there who consider empirical and scientific data to be different from facts, and who therefore proudly reject to base their decisions on evidence. Evidence-based policymaking, future-proof regulation, and better lawmaking as a principle, they all remain a constant challenge and require frequent adjustments, including with new tools and with new avenues for cooperation with interested partners and stakeholders across institutions. At the level of the EU, the nation state, and of course the level of regional entities and local communities. Other important elements to consider, and MEP Timo Wölken stressed it right at the beginning, are transparency and trust. It's key to maintain trust or to regain it where it has already been lost. Trust in public institutions and their capacity to solve problems are key in a democratic society, and honoring the principles of better regulation in decision-making processes can help in this regard. I think everyone agreed that it was important to join forces and to dialogue with all those involved in lawmaking and implementing them, so that better lawmaking in practice is not a costly and bureaucratic exercise, but a meaningful and relevant contribution to better laws for EU citizens. As far as the various sessions are concerned, I thoroughly enjoyed all of them. It would go too far to go into much detail. Let me just say, in sessions 1's lively and sometimes controversial discussion on lawmaking in times of crisis showed again how this agenda evolves, while the main objective remains the same, namely to inform decision makers on proposed or implemented regulation, hopefully fit for purpose and beneficial for the society we live in. Session 2 on anticipatory policy making looked at new tools such as European added value, foresight and stress testing, and their potential to influence policy agenda and making legislation future-proof and fit for purpose in view of frequently changing challenges. In this context, it was interesting to hear that it was widely acknowledged that we already have these tools for anticipatory policymaking, but we just need to use them better. Finally, session 3 looked in more detail on the other new kid on the block, the one-in, one-out approach. Unsurprisingly, we have seen that this tool remains controversial. And while we all share the intention to make and enact legislation free of unnecessary burden, we may need more time to see how this will work in practice. In any case, it has been a huge pleasure for all of us here in EPRS to host this event, and we are encouraged to continue. We wish to deepen the dialogue and meet again in about 1 year's time for another edition of this conference, and this hopefully in person. More importantly, we seek to create continuing practical working relationships in form of a sort of community of practice. A down-to-earth community of praxis could be a channel to establish an ongoing exchange of information and share practical insight between this Parliament and other parliamentary and regional entities, such as research services and other support structures, as well as with other EU institutions, the OECD, academia, and NGOs. If you're interested to remain in contact and to join our new community of best practice, please give us a signal by filling out the feedback form, and I'm checking if the feedback form has been published. It should be there. The feedback form, which you can find hopefully in the chat. That will enable us to contact you for this purpose. Coming to the end, I would like to remind once more that the Czech Council Presidency today also held a Better Lawmaking event in Prague, and we are looking forward to sharing notes and conclusions of these 2 events. Next year, in 2023, the 6-month presidency of the Council will be held by Sweden and Spain. We look forward to cooperate with all these Council presidencies during their term. With all these good intentions, I close the first annual EPRS conference on better lawmaking. Let me end by thanking you once more for your time, insight, and engagement. We look forward to keeping in touch and wish you a very nice end of the day. Bye.